Department, you all persons having business before this court shall draw near to their attendance and they shall hear.
Thank you. Please be seated. The first case on for argument today is case 134, People versus Joyner Pounds. Something going on. Okay, proceed.
Good morning, Your Honor. Stephanie Stair for Ms. Joyner Pounds. I will skip directly to point 2 unless there are questions on point 1. I do concede that this point is completely unpreserved. We are asking this court to reach it in the interest of justice. The way that this indictment was written, there's no differentiation between the counts in terms of which count relates to which child. Only 2 birth certificates were provided at trial. So if the court finds, based on the later points of this argument, there was insufficient proof presented on the age of the 3rd trial, the lack of specificity challenges the unanimity of the verdict. The testimony at trial furthered the duplicity in that the officers didn't specify which child they were referring to and used only vague terminology like young and younger and even younger, small kids, maybe a year, probably under 1, and then 2 older kids. Oddly, there were no car seats for the testimony of the officers, yet no charges for insufficient safety seats. And the father was present at the scene and not questioned or called as a witness. So
usually that's when these types of cases, there's some uncertainty as to whether there was a unanimous verdict. The jury is not guilty on one count, guilty on another. Here, they were guilty on all the counts, right?
right.
So everyone agreed that the mother was guilty with respect to all 3 kids. So what difference does it make what order the counts go in with respect to the kids?
So it would only be if this court found that the proof was insufficient with regard to the age of the 3rd child, because then you don't know which.
That's the 3rd child was less than a year old, is it 9 months, something like that?
Allegedly, yes.
All right. Is there evidence that, or is the law that you need a birth certificate for every child in these cases?
No,
Or like if a baby's just being brought home from the hospital, can they make you look at it and see that's obviously not over 16 years old?
right. So in other cases and in my own experience as a trial attorney, the testimony can establish that. It doesn't have to be a birth certificate. Usually, officers can testify it was in a car seat, it was still in diapers, things like that. But none of that was done here. It was just younger and just, under 15 years old without really any justification or detail on why they came to that conclusion. Which sort of brings me to point 3, the weight of the evidence. The deficiencies in how the indictment reads, coupled with the deficiencies in the investigation and the deficiencies in the proof, I think an acquittal here would not have been unreasonable. The 911 caller never connected Ms. Joyner Pounds as the driver that she was describing. She lost sight of the vehicle, gave a vague description, no information on the occupants. Law enforcement was allegedly their attention was drawn to the car by this bumper that was dragging the ground. However, the pictures presented at trial showed actually a lack of bumper, that there was no bumper attached to the car at all, which make the claims of a loud noise somewhat unreliable.
Unless it fell off.
It might have, but the record doesn't support that. The only thing that was presented at trial was a picture of the car without a bumper at all. And the arresting officer admitted she never asked any questions about the bumper, never investigated it herself, never asked Ms. Joyner Pounds about the bumper. That arresting officer also only witnessed reasonable and prudent driving. There was no breath test, no standard field sobriety test, no chemical tests. She was mental health arrested, so they could have easily gotten a court order for a blood draw. The indicia of intoxication were readily explained by other causes. Most importantly, I think her quote unquote belligerent and incoherent behavior, they admitted she was appropriately behaved until one of the officers reached in, actually opened the car door, reached in, forcibly took her phone from her hand in an attempt to provoke cooperation she was under no obligation to give. They then, 4 officers removed her from the phone, shoved her against the car, injured her face, all while her children were watching. So I think her difficulty in walking and her alleged belligerent and incoherent behavior can be explained more by the officer's conduct than her alleged intoxication. If there are no other questions, I would rest on my brief.
The questions, Counsel? Thank you.
Good morning, may it please the court, Christina Harper for the people. I will also concentrate my argument on points 2 and 3 of the brief. Regarding the point 2, the issue is certainly unpreserved. Also, Judge Renzi here pointed out, alerted the defense attorney that the children were not named in the indictment, and that he suggested that he would instruct the jury that each count pertains to each child. There was no objection from the defense based on
What
that.
if we were to agree with counsel that the verdict's against the weight of the evidence with respect to the youngest child, whatever count that may be, assuming we were to agree, big assumption, which count would we dismiss?
As to weight of the evidence,
Right. You don't have to preserve that or anything like that, but she says there was no testimony that it was a small child in a child's seat or that the baby couldn't talk or so forth. Assuming she's right on that, what are we supposed to do with the weight of the evidence?
as to the weight of the evidence, Your Honor, I would respectfully submit that the weight, that the evidence was not against the weight here, even with respect to the youngest child. And here's why. The youngest child was described as a baby. The people did present 2 birth certificates as to older children. The oldest child was seated in the front seat of the car, and there was testimony from the police officers who testified that 2 younger children were in the back seat. There was no objection as to any police testimony when police officers testified as to approximate age of the children. Also, the exact age of a child in a car is not one of the elements of the offense. What the people have to establish is that the child in a car was 15 years old or younger. So with that, also the father of the children did appear, and police officers testified that they assisted in transferring the children to his car. So with all that, I believe the testimony was sufficient to establish the guilt as to all 3 counts. And
As Justice Lindley points out, with all those very good arguments, if we disagree with you, which count do we throw out? And how do we determine that?
so the counts in the indictment certainly are not specified as to each one of the children. So it's really not clear. It's one count per child.
It shouldn't be that way, should it? It should have been.
Perhaps
The grand jury should have known which counts they were voting on, and the jury should have known, right?
perhaps it would be a better practice to distinguish. However, I would emphasize that there was no objection made, and I think everyone was in agreement that 1 count pertained to 1 child in this particular case. Unless there are any other questions, I would rest in my brief.
No other questions, counsel? Thank you.
Thank you.
Case 135, People versus Maull. Counsel, welcome. Can you both hear us?
Yes, Your Honor.
Counsel Smith? Counsel Smith, can you hear us?
I can now, Your Honor. Thank you.
Very good. I think we're ready to proceed. Proceed, counsel.
Please the court, Lyle Hoydu for defendant Maull. Since this court is already familiar with the facts of the case and my voice has limited use, I'm going to focus on the arguments I raised in my reply brief. The right to counsel is meaningless without due process to protect it. And that is a central problem in this case. Here, we have the systematic recording of all outgoing jail calls.
Counsel, if we, I recognize the concern that you raise, right? My question is this. Can there be a Sixth Amendment violation without an injury caused by the intrusion, by the listening to the recording? And if not, that's one thing. If there is an injury, what is the injury?
So with regard to the harm, we have the fruit of the poisonous tree, and then we also have this chilling effect, which undermines and impairs the relationship between the defendant and his attorney. I've outlined what I thought was the fruit of the poisonous tree. Namely, they shared the information with a co-defendant, the information implicating the co-defendant in homicide gave him a motive to testify against the defendant. And in fact, he did testify. The jury considered it, and it was one of the factors that led to the conviction. That's the fruit of the poisonous tree. The chilling effect it has is that, as evident by the testimony at the hearing, the attorneys do not trust the jail personnel. They won't communicate with their clients over the telephone. And Cattaraugus County requires, because of its remote location, travel of several hours just for a single visit. And all of that impairs and undermines this attorney-client relationship. So,
Wait a minute, you're saying that if you're held in Cattaraugus jail pending prosecution, you're being held 2 hours away from counsel in Cattaraugus County?
in this particular case, the testimony from the two defense attorneys, one who resides in Erie County and one who resides in Chicago County, was that it required that amount of time. Yes.
Even for the lawyer from Chautauqua?
Yeah.
2 hours travel?
It's at least 45 minutes one way.
Yeah, 'cause it just doesn't seem like good practice. I don't know how often this goes on, but for a lawyer, knowing that calls are recorded, to be talking about to a client on the phone in jail about the case, I would be surprised if that's commonplace. That struck me as unusual and odd here, but.
Well, apparently it's not unusual, Your Honor. There was a news report of 1,500 confidential attorney-client communications recorded across New York State prisons. So it's not an isolated problem to Cattaraugus County. And it has.
No, go ahead. Finish your answer. I'm sorry.
I was just saying it does have a very real chilling effect, as evident by the testimony of the two defense attorneys.
Does it matter, counsel, that at least in this case, there was the opportunity for the defendant to put his lawyer's name on a list? And if it was on the list, then when that call was made, they wouldn't record? At least that was my understanding. First of all, do I understand that correctly based upon my review of the record?
Phone calls are recorded unless three things happen. The inmate has to properly fill out a form identifying the attorney and the phone number. Two, the officer has to properly enter that information into the system. And then number three, the system has to work properly. And regardless of whether it's human error or technical error or misconduct, we know that those recordings are happening. And I cite that news report of 1,500 accidental recordings.
So your point is that whether that procedure's in place or not, and whether or not the defendant actually did list the lawyer with the phone number on the proper form, there's still a couple steps that need to be taken, which if those steps fail, then the conversation is recorded in violation of the Sixth Amendment. Then I guess that leads into your argument as the attorney in this case. I think at some point testified it during the hearing, Mr. Terranova, that he didn't engage in these conversations with clients as a general policy, which would be consistent with what your view is here, I guess.
Yeah, to me, that's an indictment of this system that we have in place, that the attorneys can't even trust that their communications won't be recorded. And I would encourage the court to, what's missing here are the due process safeguards that we have in wiretaps. Whereas the court will allow recordings that, if any recordings are privileged, as distinguished from an ordinary conversation between two individuals, if there's any interception of attorney-client communications, it has to be immediately brought back to the court. There's going to be an opportunity to suppress that information, make sure it doesn't go out.
Counselor, there's a distinction between recording the calls and then listening to the recording, isn't there? I mean, in this case, there was a mechanism to, at least according to the authorities, to prevent recording if the defendant had followed the procedure. The recording wouldn't have taken place. He didn't give the privileged phone number. But as I understand your argument, that's not really the issue here. The issue is that recording was then listened to, and there were 3 separate recordings that were listened to, and that from the context of those recordings, the investigator should have understood that was a privileged conversation.
I acknowledge the distinction that you draw, but my point is, regardless of how the recording happened, and it could be, perfectly innocent, there always should be an opportunity to have that brought to the attention of the attorney and the defendant, so that they're on notice, that they have an opportunity to argue that should be suppressed and not used against them at trial, and perhaps most importantly, it would prevent any future recordings from happening. That
you're not advocating for a rule that if there's an unlawful listening in on a lawyer-client phone conversation, that it automatically per se results in dismissal of indictment. You're just saying there should be any fruits from that conversation should be suppressed.
Well,
that's your argument, I believe.
Obviously, the fruits should be suppressed. The problem we have here is it's such a systematic intrusion on it that the right to counsel, which, that carries with it an assurance of confidential communications. It's a constitutional protection of the highest order. And if there is any waiver of that, it should be knowingly, voluntarily, and intelligent. We should not be saying that we're going to infer it merely because there's a warning, an automated warning. And in fact, the superintendent of the jail was uncertain whether that automated warning was given, regardless of whether it was recorded or not. So that warning...
Counselor, I'm kind of back to where we were with the presiding justice at the beginning of the argument. I think what I'm hearing from you now is that the fact that, it's undisputed, right? that the lead investigator on the murder that your client was ultimately convicted of listened to 3 recordings of a conversation between your client and his then lawyer, albeit on another matter. That seems undisputed. And if I understand your argument today, it sounds like you're saying there in itself, the fact that he listened to it constitutes all the harm that your client needs to show to get some sort of remedy. But the way I read your brief, Counselor, was a little different. I thought you were arguing that because the tape, it was listened to and the material was turned over to the co-defendant's attorney before he agreed to cooperate with the prosecutor. I thought you were arguing that the harm from the phone calls being listened to was by virtue of the fact that the co-defendant became a witness against the defendant. So I'm caught. Are you saying the former, that is the harm that can be remedied, is the listening to the conversation itself? Or, as I read your brief, do you think it has to be something more that is harm to the defendant vis-a-vis the trial?
Well, I think it's both, and I apologize if I haven't made that clear. The harm encompasses one, which is the fruit of the poisonous tree. And the second harm is that this, because of the chilling effect it has on the relationship between the attorney and the client, where it impairs their ability to freely communicate without fear that their conversations are going to be recorded. It undermines the right to counsel. The argument is, what good is the right to counsel if you don't have due process to protect it? And the due process we're looking to protect it would require notice of the recording, an opportunity to seek a remedy with the court, and some assurance that we're not going to have this. This is not unique. This is a systemic system designed across New York State.
Counsel, if I could, in this case, do I have it right that his attorney received the notes prior to the trial? The notes of, I think it's Detective Crossan. Do I have that right?
Yes.
And in the notes, Crossan indicates the 3 conversations that he or she listened to. I think it's a he. And that, and further, there's even a notation that it's clear from the notes that Crossan identified the person speaking with the defendant as the attorney or lawyer. And so once counsel had those notes before the trial began, your argument is he did not go further at that point. He did not take the step that you're suggesting, and that is challenge this on the constitutional grounds. Do I understand that right?
The notes themselves were received as part of Rosario prior to trial. Defense counsel did nothing with the notes. However, the actual recordings were not disclosed until the defendant filed a 440 motion post-conviction. So those were actually withheld, and they contained additional information that was not simply revealed in the notes.
But none of those notes, nor were the recordings admitted at your client's trial. You're saying that the taint, because we need a taint here, I think. You're saying that the trial was tainted because the co-defendant testified against your client, but for the unlawful listening into the phone call, the co-defendant wouldn't have testified. Do I understand it right?
That's a good summary.
But what did the co-defendant testify specifically that the co-defendant didn't already know? I mean, he was involved in the crime. What did the co-defendant learn from the surreptitious recording that wasn't already in his mental possession?
Well, it wasn't that it gave him knowledge. It gave him a motive to testify, that he may not have testified, but for revealing that the defendant was implicating the co-defendant in a homicide. So that was, they used it to motivate the co-defendant to testify, and it became part and parcel of the proof that the jury considered in reaching its verdict.
Anything further, counsel?
No, Your Honor, I'll rest on my papers. Thank you.
Thank you. Counsel Smith.
May it please the court, District Attorney Ashley Smith, appearing on behalf of the respondent. Your Honors, I'd like to start with focusing on points 2 and 3 as contained in the brief. Your Honors, I would argue here that there is no taint that came from the summarized notes from the investigator in this situation. The district attorney herself testified that she had no knowledge of those summarized recordings, as well as it's already been indicated that the defense attorney, Terranova, was in receipt of those recordings. And the co-defendant that was in receipt of those summarized notes, it's argued that that provided motive for him to testify. But as you're aware, there are a multitude of reasons why a co-defendant may testify. And in this instance, I believe the co-defendant was offered a reduced charge, which that's contained in the record. So there's nothing to support this allegation that the co-defendant was motivated to then testify in that trial against Gary Maull.
Counselor, let me just interrupt you real quick and don't lose your train of thought. But I mean, here we have the lead investigator for this murder that listens to these conversations. And there's no question, everyone agrees that was wrong, right? That was wrong to do. Absolutely. And I make no excuse for that, Your Honors. Instead, I'd rather focus on the fact that although that occurred, nothing from those summarized calls, nothing was used from that in the trial. There is nothing in the record that supports that. And so what about the lead investigator's testimony at the hearing that we required, where he seems to indicate that he later went in and changed his notes to reflect, oh, that's when I knew later on that he was speaking to a lawyer. And Counselor, I have to just fess up, when I listen to those calls, it's pretty clear to me at least that in the very first call, the person that was getting the call said, I've just got back from court. And they clearly were discussing legal matters. So this testimony from the investigator that he went back and filled in the gaps, oh yeah, that was a lawyer, that sounds borderline of being incredible as a matter of law. Don't you agree? Your Honor, I do agree. I listened to the recordings myself and quite frankly was very disappointed. Okay. I then refocused myself and can assert to you, though, based on my review of the entire record, there's nothing to support that there's any taint that resulted from that, although very improper and offensive. Nothing supports any taint in this instance.
Well, why don't you, Counsel, then let's address, I believe what your opponent says is the taint, and that is that the co-defendant wouldn't have testified but for the listening to the recordings. How do you answer that?
Well, Your Honor, there's nothing in the record to indicate that that motivated him. The district attorney herself was unaware. She took the position that she was unaware that she even knew about those summarized recordings, therefore could not have been something that she put forth as a basis for that co-defendant. And as I indicated, you know, co-defendants are motivated by a multitude of things. And in this instance, the co-defendant was offered a reduced plea. And I would say that is in the record and he was heavily cross-examined on that issue in the trial, and therefore was most likely the most, at least in the record, motivation for him to testify. And the notes that were taken by that investigator, you know, at best did not provide, you know, sufficient context, even for the defense attorney, Terranova, or even for for Maull or for the co-defendant Hall.
Well, counsel, I'm glad that you acknowledge here in open court that the recording, that listening was wrong. We've had 2 prior decisions where this court has said that, and I got the sense from the testimony that the investigator still does not agree, and the trial court judge who entertained the motion may not agree. Said the police had no duty to stop listening, among other things. So I'm glad that we made progress on that. On the tape, though, assuming this is even something you could suppress, somebody's motive to testify, would we not need a hearing of some sort to put the co-defendant under oath? Why did you cooperate here? What were the factors that influence your decision? Or is that something we can just rule on as a matter of law, up or down?
Your Honor, I would say that a hearing would be required. And in fact, in this instance, there was a hearing and there was an opportunity for potentially the co-defendant or the co-defendant's attorney to be part of that hearing. That did not happen in this instance, but certainly to determine what someone's motivation would require a separate hearing well beyond what you have before you. It's just not contained in the record. As to the issue regarding defendant's right to effective assistance of counsel, I think the record is very clear that Gary Maull received meaningful representation. A disagreement about a strategy or tactic, narrowly looking at that is not enough, but taking the totality of the circumstances, believe that this issue is very clear that he received effective assistance of counsel, and therefore that relief should be denied. And if there's no further questions, I would rest on my brief.
Thank you, counsel. Case 137, People versus Owens.
Yeah, please, the court, Brian Jones for defendant appellate Philip Owens. This is a case where several errors and significant errors occurred. They were made at the trial court and were cumulative. It's a case where the defendant arguably acted better than the judge. Here, the defendant was sentenced 3 times. He was sentenced, resentenced, then there was a resentencing of the resentencing because the judge couldn't get it right. He believed that his notes were correct. The first sentence was not what was pled to. The second sentence was also not what was pled to. It was pointed out by defense counsel, the district attorney, the defendant, but he proceeded anyways. Eventually, when it was caught, another resentence occurred to correct it to what the plea was to.
The plea was to 5 years PRS. That was
At one point.
right. At the beginning, the offer was stated 5 years PRS. And then when they came back, were sentencing the first time, the prosecutor said 2 years, which isn't even legal.
Correct.
The court enforced 2, which was not legal. So it was a break for the defendant so far. The
Yes.
defendant ends up with 2.5, still a break, because he's supposed to get twice what he agreed to.
Yes.
So the harm is what?
The harm is more related to him attempting to be heard and put his request to withdraw his plea on the record. And he spoke respectfully. He was articulate. He could
He's
continue.
making legal arguments, but I think the judge was of the belief that he had an attorney, and you don't have hybrid represent. You can't, if you have a lawyer, you can't start making legal arguments. I think that was my take from what Judge Renzi was saying. Am I wrong on that?
No, that's my understanding, that part also. But my understanding is also that he was starting with that and attempting to get on the record why he was moving to vacate his plea, but wasn't given the opportunity to get to the point where he could address what was wrong with the plea or the voluntary knowing willingness aspect of it. So.
And his attorney, though, didn't speak up,
He did not.
stayed silent. And there's no claim here that the attorney was ineffective for doing that.
Correct. My understanding is there was some disagreement between the two and that he had wanted to speak and was attempting to do so, but was not permitted. So, and if there's no other questions at this point, I'll rest on the papers.
No other questions, counsel?
All right.
Thank you.
Morning, Marty McCarthy for the people. In terms of the way, which issue do you want to talk about? The resentencing issue?
Well, why don't you talk about what you need to talk about?
Well, as you were well aware, the court improperly I think you called it a re-sentence. It did so in the defendant's absence. So,
What are we supposed to do with that? We remit it and then the defendant can be sentenced in front.
I
The judge can
believe,
sentence the defendant in person.
I believe that you have to in that scenario, when there's an absence of the defendant has a fundamental right to be there for his sentence. And the pronouncement sentence, and as you know from K2, post-release is a mandatory portion of that sentence. So
And what sentence would be, does he get the 2 or the 2.5 or the 5 for PRS?
That's a good question. Because theoretically he could get 5 because the range on it was 2.5 to 5.
I thought he was told 5 at the plea.
I don't know if you're wrong. That might be true because it is true actually, because then when the DA came back and said 2, that was also wrong. Or that was definitely wrong.
But 2.5 isn't an illegal sentence.
No, it's not.
Right.
And it would be my position, it'd be 2.5.
Yeah, because if he takes an appeal and then all of a sudden he's punished for taking the appeal and it goes from 2.5 to 5.
And I would not be advocating for that. And I'm sure that the defendant wouldn't be advocating for that either.
So
So
if it can't be 5 and it can't be.
It can't be 2.
It can't be 2, so
Can't be 2.
you landed on 2.5.
my position is it should be 2.5. My position is it can't be 2. Any other questions?
No, thank you.
Okay, thanks.
Case 139, People versus Sagal. We're going to test your voice against counsel, so bear with us. Proceed.
Please the court, Lyle Hoydu for defendant Steinagle. We essentially filed a brief requesting the court modify sentence in the interest of justice. And if the court would allow me, I just would like to outline why I think we have a compelling record with extraordinary circumstances that would support relief. 57-year-old woman, no prior criminal history. She's gainfully employed. She has active and healthy relationships with family and her community, and she's otherwise leading a quiet and productive life before she meets the co-defendant. As a result of that relationship, she's subjected to physical and emotional abuse, and unfortunately, that also leads to the present charges because there was physical and emotional abuse of the co-defendant's daughter. But upon arrest and during proceedings, she freely admitted her fault. She's expressed remorse. She's engaged in rehabilitative programs. And what is more, she also voluntarily cooperated with the district attorney's office on prosecuting a homicide. And the concern is that she received no consideration of these remarkable factors, and she received no benefit. So
She did. She was charged with kidnapping first and kidnapping second. Seemed like a pretty solid case. The maximum for kidnapping first, 25 to life. The minimum for kidnapping first, 15 to life. She pled down. She was allowed to plead down to kidnapping 2. range of 5 to 25. She gets 8. The facts are horrific. We don't see too many. I mean, this was awful what happened here. So I think the way the people might look at it is your client did get consideration. She got 8 when she could have gotten 25 to life.
I think the measure there, Your Honor, is when compared to the sentence imposed upon the co-defendant, who was more culpable and also who hadn't provided cooperation with the district attorney, that there should have been some benefit to that. So we're measuring it against the sentence that was imposed against the co-defendant.
Counsel, we deal with those cases a lot, and we do that analysis sometimes, you know, where you look at the co-defendants but I'm not sure that that's the appropriate way to view this one. I mean, first of all, it's an agreed upon sentence, right? The agreed upon cap was 9.
Yes.
And so it's under the 9. All the factors Justice Lindley just pointed out to get it down to the cap number are things that we have to consider. And although it's fair to wonder why the co-defendant received the same sentence, I don't know that informs us that her sentence was harsh and excessive.
Well, when considering all the factors of the case, Your Honor, it's always in the discretion of the court, we would respectfully argue that she should have received some consideration, which would have been reflected had her sentence been less than what the co-defendant received.
We'll take a look at that, counsel.
Thank you, Your Honor.
Anything further?
No, Your Honor.
Thank you. Counsel?
May it please the court. Good morning, Your Honors. Tabitha Salonen for the people. Now, defense counsel started off by expressing circumstances that they believe are extraordinary to warrant a modification of the sentence here. However, contrary to defendant's contentions, the circumstances of this case do not warrant a modification in the interest of justice. The circumstances of this case really are that the defendant beat a child victim.
We understand the facts of this case. Let me ask you the question that your opponent raises, and that is, why are the sentences the same here? In other words, is it a fair argument to say that the father of the child, who didn't cooperate with the district attorney's office on a separate matter, should receive a higher sentence than the defendant in this case received?
Your Honor, the court addressed that within the record and expressed that while there are circumstances that they consider that was presented by the defendant, both defendants are equally culpable here. This is long, as your honors are aware, this is long-standing, a continuous torture and suffering that this victim had to endure. And if this defendant wasn't as equally culpable, then maybe they could have stepped in within the nearly 2 years of suffering.
I think the problem for the defense, because I do find it hard to believe that they are equally culpable. The co-defendant's a lot younger than this defendant. This defendant's been a mother, grandmother, lived without incident. I find it hard to believe that her role in this was the same, but I can't say that for a fact. I don't know what happened here, who beat the child more regularly, who did what to this child over the course of this period of time. So that's why I have a hard time disagreeing with the trial court, because within this record, I don't know which acts were committed and how many were by each of the two.
I certainly understand your position, Justice Lindley. However, I think that the analysis doesn't fall with how many times this particular defendant beat this 13-year-old child.
Whose idea it was? How did this come underway? But look, the fact that one co-defendant might be sentenced leniently and the other defendant sentenced fairly, I don't think that's a great argument to give lenience to the other defendant here. In other words, if we could, which we can't, I'd increase the sentence on the other guy, but that's not within our jurisdiction.
Your Honor, It's the people's position that both defendants received a very appropriate sentence, considering, as you previously pointed out, that they were facing originally 25 to life, and then thereafter for this plea, 25 years. And they received, under the commitment, which was originally 9 years, they received 8 years. Also, it is my understanding that the defendant was not ultimately called to testify regarding the cooperation. The nature of the cooperation was addressed by the court, so the court knew of that prior to issuing their ultimate sentence here. Furthermore, it's also my understanding that the cooperation here was outside of the scope of the original plea agreement. So therefore, and also defendant admitted such within their reply brief. So therefore.
But that's not unusual, right? I mean, we do have cases like this where there's a plea put on the record, but before sentencing, the person's in jail, they hear information, they reach out to the DA wants to get that information. And so then they come back into court and say, we're gonna talk about maybe some leniency on this. And they maybe put off sentencing, or maybe they do something else to reduce the range of sentencing. I mean, that's not unusual, the fact that it's outside the plea, right?
Well, that's correct, sure, Your Honor, but it's also not unusual for a defendant to have remorse when they're sitting in jail for a while regarding the abuse that they engaged in here on the victim, as well as it's not unusual for a I also think that it is a good point that you bring that up, because the court did have ample opportunity and time to think about what they were going to sentence this particular defendant with. They have discretion here, and they ultimately decided that they were equally culpable and took every single mitigating circumstances into consideration.
Thank you.
Yes, Your Honor. If there are no further questions, the people will rely on their brief.
Very good. Thank you, counsel.
Thank you.
Case 141, People versus Mitchell.
Good morning, Your Honors. May it please the court. Matthew Albert on behalf of Mr. Mitchell. Your Honors, I was going through all the written materials relative to this matter. I don't have a ton to add in terms of legal reasoning. I do have an analogy I wanted to bring before the court that I think potentially we as Western New Yorkers can identify with, and I think it's germane to the proceedings at hand. If the Bills were playing the Chiefs in a big game, and the ref prior to the game says something along the lines of the Chiefs are going to win the game, and then in that game, all the calls go against the Bills. And then he imposes 29 penalties against the Bills, just like the 29-year maximum sentence that was imposed against my client. Would we, at the end of the game, or would anyone, would any reasonable mind be confident in the integrity of the proceedings? Or instead, would serious doubt be cast upon the integrity?
Counselor, in that example, would the coach have any obligation to object to what the ref said at the beginning of the game?
I wouldn't believe so, because let's think about
it. In a court, though, you would have an obligation to make some sort of motion to disqualify or recuse or object in some way to bring it to the court's attention to make the court rule on whether or not it should get off. My recollection, that didn't happen here. Am I correct?
You're correct, but there's certainly no case law that speaks to the fact that that is the obligation of a defense attorney. But moreover, Your Honor, I think it's a situation where at the time, not every exact word is heard. And in fact, sometimes something so shocking is said that you think it couldn't have been said. But that's why there's a record, and that's why we rely on these.
Aren't we more concerned with the actual rulings, or the calls by the ref, so to speak, or the evidentiary rulings here? Did the court get them right? And do you want to address those? I think you complain about the evidence of the extramarital affairs that was precluded. You complain about preclusion of psychiatric evidence for the defense of the military background. If the court was wrong about those, then we would reverse, regardless of any perceived bias. If the court's right on that, then wouldn't we affirm?
I would say no, and I'd refer to the People v. Neymar case, and that's where I'm going next. And a direct quote from that case. And that was a case granted from 1913, still good law, in which the reviewing court, the appellate court, could not find any clear errors or any indication of any kind of bias within the record. But what they did say, based upon the lower court's statements relative to the defendant's guilt prior to trial commencing, was that the idea of a judge presiding at a trial committed in advance to the theory of the defendant's guilt and to a determination to administer punishment up to the full limit of the law is destructive to that conception of justice, which pictures her with blinded eyes and is shocking to our sense of judicial fairness. Bang. I think we're talking, that's directly on point to the proceedings at hand. So certainly we could, there's counter arguments to a certain extent as to the legitimacy of the lower court's rulings, but I think the word committed is very apropos in the ruling to this case, as well as it's the same word, and that's when Neymark references committed in advance to the theory of the defendant's guilt, as it's the same word the lower court said when predetermining Mr. Mitchell's guilt. He committed the crime of burglary. It's, namely, Miss Mitchell's extramarital affairs, irrelevant. And I think such a line is fatal to the integrity of the proceedings for two reasons. One, it does prove that just like in Neymark, that the lower court was in fact committed to the theory of my client's guilt. Moreover, it proves that the evidentiary rulings were shrouded and clouded, tainted by that same predetermination. I don't want to hear about Miss Mitchell's motive to fabricate. Your client committed a burglary. That's what was said. And again, I think certainly viewing everything in its totality, there's red flags all over the place, but I think the court called their shot ahead of time, subconsciously, demonstrating their belief, their clear-cut belief as to my client's guilt before a shred of evidence was heard. And I think the reversal is mandated.
What was the defense here? I think he acknowledged that he used a sledgehammer to break the door in.
Right.
He acknowledged there's an order of protection. He shouldn't have even been there.
Right.
What was his intent? The defense on the burglary was that, yeah, I brought two sledgehammers and screwdrivers and all this stuff, and I banged my way in, but my intent was not to commit a crime inside. I was going to do what that was lawful. What exactly was this?
I'm sorry.
Defense there?
Sorry to interject.
No, it's fine. Go ahead.
I don't dispute necessarily the fact that there is some strong evidence, on the part of the people, as there is in many domestic violence cases, but the presumption of innocence is to all, those who there's strong evidence against and those to who there's more questionable evidence against. In this instance, there was one defense, and that goes to the element of intent. That's the highest culpable state in the penal law, and it goes to one's conscious objective. And certainly there is at least a line of reasoning and some arguments to be made as to the uncertainty as to what my client's intent is. And I think I laid that out.
He said, I'm not after you to the father, I'm after her.
Well, I think the interesting part is that was not said at any previous part of the proceedings. That was not said in the father, Mr. David Boersma's statement that he made to the police. It was said at trial some 3 or 4 years later, and then I was not allowed to cross-examine Mr. Boersma as to that prior omission, which was another ruling that I believe goes to the fundamental due process and goes to the fundamental integrity of the proceedings. So with that in mind, I would also point out that, and I put this as an exhibit, there is audio of this interaction at the door. And at no point is my client heard saying anything like that. So,
well, the phone was quite a distance away. It wasn't like right next to the defendant. It seems like and I understand you're advocating strenuously for your client, making a lot of good points. This bias issue, it's not irrelevant to the sentence, is it? I mean, it does seem like a pretty heavy sentence. We just heard a case. You're talking about comparing co-defendants in the same case? Comparing co-defendants case to case, 8 years for what happened there, 29 here. Nobody gets hurt here. It was terrifying to his family, but that, do you want to talk about that? Was there a pretrial offer with a sentence?
yes, the court indicated they would commit, I believe, to a 15-year sentence. I think they said they would cap it at a 15-year sentence, but the court also indicated that's where it would go. And frankly, you're right, Your Honor. Having done criminal law for 20 years, this was perhaps the most excessive sentence that I've come across.
The sentence got doubled for exercising his right to trial.
There's that, but also there was a wealth, an abundance of mitigation materials that I have not necessarily had the benefit of in prior cases, namely his PTSD from his military service, his traumatic brain injury from his military service, the fact that this all happened during the course of this COVID epidemic, and he lost his mind and he lost 40 pounds and he was eating cigarettes for dinner, so to speak. So with all that in mind, this to me, I don't know, but a 4 or 5 year sentence would seem far more appropriate in this instance than a 29-year one.
Counselor, I just want to be clear here. He came to the door, he smashed it in with a sledgehammer.
Right.
And in the course of that, he said, he was there for purposes of to get to his wife. And she suffered a broken wrist trying to blockade and barricade the door. Meanwhile, her father was there trying to protect her with a lead pipe. Those are the facts.
Those are, what I would say is this. In terms of the phone being away from the door, we did hear quite a bit of the encounter, and we certainly heard Ms. Mitchell screaming. What we did not hear was my client, who's right there on the other side of the door, supposedly with a hole in the door at this point, and we did not hear him say anything. We had a wound to the back of his head, which is consistent with his testimony that he submitted, that he was acting upon impulse, did not know what he was going to do. But I think
Time out. Didn't he have to get to the home first?
Sure, yeah.
So that would be some time to get to the home, right? Because he was living with his sister or relative.
Grandmother.
And got to the home, 7 p.m. on Thanksgiving Day, climbs over the back fence with a knapsack on his back, carrying what one victim described as the largest sledgehammer he's ever seen in his life. And in addition to another sledgehammer, comes over and cuts off the power to the house at dark before he starts slamming the large sledgehammer against the door. So when we're considering the sentence and then listening to 9/11 tape, which is a lot of screaming there, it's difficult for me, Mr. Albert, very honestly, sir, to say that a long sentence was not deserved here.
And I understand, and I certainly think, and I conceded throughout my brief that certainly there's a line of reasoning that would tend to support the proposition that my client is guilty. I think there's also evidence that could potentially counter at least some of those points. It was not allowed in, which I think is something to certainly be considered. But I also think, if we're talking about forest through the trees, there's lots of guilty people, no question, in criminal law. They all are deserving of a fair and impartial judge who has not predetermined guilt and who is not committed to giving them such a staunch sentence upon going to trial, and he did not have that here. So certainly, I'm not condoning the conduct, of course, and I submit that there's a valid line of reasoning. This verdict was not against the weight of the evidence. That's not an argument. I'm not contending it is. I think there's certainly also some counter evidence that could amount to potential reasonable doubt in a juror's mind that was not allowed in. But more to the point, Judge, I really think that those cases, and they go throughout history from Neymar to the Fourth Department case in Greenspan, or I might be pronouncing that name wrong, but everyone is entitled to a fair and impartial, unbiased judge who has not predetermined a defendant's guilt, and my client did not have that. And based upon that, this case demands reversal where he gets that, and then the chips will fall where they may.
Thank you, counsel.
Thank you.
Morning, Your Honors. Michael Hillary for the people. I reject the premise that the court had predetermined the defendant's guilt, notwithstanding the remarks that the court made. Some context is in order as well. This was a motion in limine that was about a week, if I recall, about a week before the trial. And the issue was whether or not the defendant would be able to get into alleged instances of infidelity on part of Ms. Mitchell here. And the court had said, in essence, we have strong evidence of a burglary here. This is what he's charged with. Whatever you might bring out in the realm of infidelity does tend to undermine that. It's not something the court should do, given the impact it would have on the people's case and on Ms. Mitchell's credibility before the jury. So it was a balancing test that the court had to conduct there.
It's a clearly proper ruling. You can't attack a spouse who has had an affair, even if it occurred. I don't know if it occurred or not, but that's just not relevant evidence, period.
I believe the court did not in any way abuse its discretion in that ruling, and as well as the other.
Psychiatric, because he's suggesting here that if there's other evidence let in, it might have been mitigating, might have been led to a different result. Extramarital affairs, no. Proper ruling. Psychiatric defense, it was untimely. Winning on the insanity defense almost never ever works. That leaves us with, he believes he wasn't allowed to inform the jury fully about his military background. He did testify to his status and some of the things he did, but I guess he wanted to go on more on that. You want to hear about it? Does he have a claim there on that one?
I certainly understand Mr. Albert's point as to why he would want to get into that. And the idea is that he had expertise with regard to a long-range operation, if you will. He could have done this without the intimacy involved of going to the door and hitting it with a sledgehammer. But Judge, I can't say that this is an abuse of discretion by the court to disallow that, especially given what Justice Lindley, you already indicated, that the court allowed him to get into his military background. His rank was elicited. I believe the years of service, 17 years, was elicited. The jury would hear plenty about his military background, but not so much that it would interfere with the issues of the trial.
But he wanted to testify, apparently, look, I'm a trained military man. If I wanted to get in that house, I would have gotten in that house.
That's
That
right.
seemed to be the only reason he wanted that. Well, he got in that, I mean, that I'm not sure where that was leading to. But this sentence on the surface, 29 years, does he have a record at all? Any priors, this defendant?
I do believe he has priors, Judge. I can't say what they all are at this point, but I would also note to the court that he did not accept responsibility for this crime when he was interviewed. He blamed Ms. Mitchell, in fact, for this crime. So in addition to a history, he did not accept responsibility. And as Justice Del Conte, you pointed out that the facts here are horrific. And you had an 11-year-old and a 6-year-old child, I believe. The 11-year-old has got the 6-year-old in an attic, and she's got a fork that she's holding in case the defendant should get inside. You have Altair breaking loose outside. This was an ordeal that they're going to have to live with for a very long time.
But do you agree counsel indicates there was a pretrial offer of 15 years?
I believe
Right?
that's correct.
And that's
Yeah.
knowing all the information you just gave us. There's a pretrial offer of 15 years. And so how is the ultimate sentence, how do we look at that increase in sentence as not some kind of penalty for going to trial?
Well, a court can enhance a sentence from a plea based on what it learns at trial.
What
And
did the court learn potentially at trial here that the court did not know in advance?
I think a lot of the history of the interactions between the post order of protection between the defendant and Ms. Mitchell, this wasn't an isolated incident where the defendant shows up in violation of the order. And
Aren't those the kind of things that would be information that your office would provide to the court in contemplation of a sentencing commitment? And the defense would be in a position to offer counter information so that the court has full information before it ultimately decides what commitment the court would give to the defendant, right? The court wants to be fully informed at that point. And your office had that information. Presumably, your office would have provided that to the court, no?
that's a fair point, Your Honor, and no doubt that information was presented in some form to the court, but I would only suggest that when a court hears testimony from the witnesses, it has a way of putting things into a clearer and fuller perspective. And hearing from
which is why I think a court should, in the right cases, maybe increase a sentence. But this is a dramatic increase, right? I'd be looking for something dramatic to justify this increase.
But again, Judge, I would suggest that if the defendant had accepted responsibility, perhaps that would have mitigated the enhancement of the sentence from the plea offer.
And Counselor, sentencing, didn't the victim who had the fractured wrist and didn't her parents who were in the home at the time give statements to the court? There, that's, it's not just limited by the rules of evidence. There, they kind of laid out what they were concerned with this defendant. I think there was also a letter read from one of the children.
I believe that's right.
I think another child may have spoken. So the court also can consider all those statements at sentencing because that's why they're given at that point, as well as allowing the defendant to speak.
That's absolutely right, Your Honor. So the court had so much more information at its disposal. Even
I don't think anyone would dispute that on a 15-year sentence, you turn it down, you go to trial, you're not getting 15. It's the question of doubling it. Do you give them 5 more, 3 more, 6 more, 10 more? There are reasonable arguments as to how much more he should get.
I think it's very fair, Judge. And I would only just finally conclude with, again, the act itself and what defendant himself said about that act, which is that it was meant to be symbolic. This is the defendant's word. It wasn't meant to be something that actually led to their harm. It was meant to make a statement. That is quite a statement. Nighttime, a bag with a large sledgehammer, another hammer, cutting off the electricity. This is Thanksgiving night. And then terrorizing the family for all the time it took for him to bend that door in half, steel door. So I would just conclude on that unless the court has any questions.
Thank you, Counsel.
Thank you.
Case 142 in the matter of Matthew J.
Morning, Your Honors.
Counsel, we'll wait just 1 second here. Counsel Whiteside, can you hear us?
I can. Can you hear me?
I can. Thank you very much. Counsel, proceed.
Leah Weiss for the mother in this case. I'd like to just address mootness. There was a motion to dismiss this appeal. The AFC and the department have renewed their contentions that this appeal is moot. But I think the Court of Appeals in matter of Veronica P versus Radcliffe A makes pretty clear that an appeal is not moot if an appellate decision will eliminate readily ascertainable and legally significant enduring consequences that befall a party as a result of the order which the party seeks to appeal. Very much. And this court has held in matter of Tyler W that a finding of neglect is a permanent and significant stigma. In this case, we are not appealing anything about the dispositional order, which of course is moot at this point, but just the finding of neglect. So we'd be asking this court to not dismiss this appeal as moot. And I would rest on my brief as to point 2 unless the court has any questions.
No questions, Counsel. Thank you.
Thank you.
Counsel?
Yes, Your Honor, may it please the court. I'm Mary Whiteside for the Monroe County Department of Human Services. We do believe that this appeal is moot. This is not a situation which the different from the cases cited by the appellant. We're talking about a permanent neglect finding that encompasses the same period as the neglect finding. And that's that the permanent neglect finding is not, it was knowing, intelligent, voluntary. The admissions were found to be to a clear and convincing level, which is a higher standard of proof than the neglect. And there was no indication that that the period of time for the permanent neglect, which is encompasses, but is also longer both before and after the neglect, that this period of neglect was somehow excluded from that admission to permanent neglect. The cases cited didn't deal with the same time period, the same types of allegations.
Let me ask
same
you something,
children.
but the cases that you're relying on, they stand for the proposition, the final disposition renders it moot. Was this a final disposition?
We believe that it was a final disposition, that that the fact that there is a that there was a summary judgment does not remove the finding of permanent neglect. In regards to that, that period is almost finished. There is a violation petition that is being drafted and will be filed. The mother is not doing well in her services. The children are not in any way going to be going home. We're in the middle of a no reasonable efforts trial. So this is not a case where things have improved in the subject matter, or I'm sorry, in the summary judgment period. And, as far as, we're concerned about the facts of it, the finding of permanent neglect also conveys a stigma, a very significant stigma. So there's no way that getting rid of the neglect finding is going to undo that stigma that's going to continue. And so that, that's really, it's not compounding different neglects versus different children in different time periods. This is the same children, and it encompasses that. Moving on to, so we would ask that it be found moot and dismissed. Moving on to, my second point, which is that the finding of neglect should be affirmed anyway, that it's supported by a preponderance of the evidence. I feel that the facts on that are very clear, and that it should be affirmed if you decline to dismiss it as moot, and I would take any questions that the court has.
No questions, counsel. Thank you.
Thank you.
Good morning, Your Honor. Susan Maris, attorney for the children. May it please the court. Regarding the mootness issue, although most of this court's decisions are permanent neglect finding with the termination of parental rights, the fact that this is a suspended judgment doesn't affect the permanency finding. There's been a finding of, and it was on consent, of permanent neglect. That has the same stigma as a finding of neglect. And additionally, the Court of Appeals makes clear that an appeal is moot if the court's finding here will not result in immediate and practical consequences. It won't. If the court reverses and doesn't find neglect, we still have the finding of permanent neglect.
But doesn't that Article 10 finding get that crop up in a future proceeding perhaps? And that stigma and her record, like she neglected these other children, doesn't that have some ramifications here?
It certainly does, Your Honor, but as this court has held, so does a permanent neglect finding. So the permanent neglect brings up the same stigma. So it's not relevant with a neglect finding. Even if this court reverses, says no neglect, which the evidence supports neglect, there's still a permanent neglect, which has the same significance, same stigma.
What's the harm with dismissing it? With dismissing this appeal?
Because it's moot. I mean, that's why this appeal should be dismissed, because it's moot. This court has consistently held a superseding permanent neglect, albeit with a TPR disposition, renders the appeal of the neglect moot, and this court has dismissed.
I guess my question was, if we reversed, it has no practical effect on the mother or the children, right?
I don't think so.
But she's got one fewer finding on her record.
She already has, I think, 2 or 3 neglects. I don't know that, adding or subtracting will affect this case. It truly should be dismissed as moot. And as far as the
Counsel, let me just stop you there just for a minute so that I understand the argument. So you're saying that it doesn't have an effect because of the permanent neglect finding. So this case would just be, because she's already got that on her record, what's the difference here? Therefore, this should be mooted out, right? Is that what you're saying?
That the permanent neglect finding has the same stigma as the neglect.
But if going forward in another proceeding down the road, a family court judge were to look at past proceedings, isn't there a compiling issue that happens? And not unlike in a criminal case where there's a number of prior criminal convictions, they start adding them up at some point, and each one that you add up is a harder impact. Wouldn't that be the case here, or am I misunderstanding how this is applied in family court?
No, I don't think you're misunderstanding. I don't think counting between 4 and 5 is going to make that much of a drastic difference if this court were to reverse or not to reverse. But so we'll get to the merits then if this court doesn't want to dismiss.
Proceed.
The merits are very clear. There are 2 distinct separate grounds for neglect. The excessive corporal punishment, which to me was more of physical abuse, and the unsafe, inadequate housing situation. So as far as the excessive physical abuse, 2 children had serious bruises on their face. One child said she threw a book bag at the child's head. And all the children said, when my mother drinks, she gets mean and she hits us. Clearly, these children are in imminent danger from this mother's physical abuse. And even one case of physical abuse supports a neglect finding. So clearly there's evidence to support the neglect finding based upon the excessive corporal punishment. The second issue.
The conditions they're living in, I mean, I have a note here that one of the children reported that rats were keeping her up with screams at night.
Yes, and she was scared of them. The living conditions were deplorable. The mother agreed that the living conditions were deplorable.
She had another place to live, but she was just going over there to drink and leaving the kids here, right? The mother.
Yes.
They did give her money to find another place, right? And she didn't bring the kids over.
Nor there's really no evidence that she was actually living at the new place on Plymouth.
She would go over there and do whatever. But
I'm not sure. That's just not in the record. But in February, she was offered emergency housing at the Motel 8. She said, okay, and she never went. In March, she said she had the keys all set to move into the new place on Plymouth. She didn't leave. And then in April, and I believe April 23 was when there was a new report of physical abuse. The Department of Human Services went to the new home. The mother was there with a sick child, but all the children would get in the bus at the old place. So it's speculative, but I don't think she ever moved to the new place. So she continued to stay in deplorable living conditions with black mattresses, rat infestation, cockroach infestation, and clearly DHS gave her the means to leave and she didn't.
So I know I'm going to turn back the clock with one quick question, then I'm done. But on the mootness, because we get this a lot, and I want to make sure I understand how it works. If we dismiss appeal as moot, the underlying order is vacated, is it not? That's how we do it?
I don't think so. If the appeal's moot, the underlying order
is vacated and doesn't stay in place. That's my understanding. But I just, you may want to look at that. But if that's the case, it may change the analysis.
So I didn't see that in any of the cases cited where this court dismissed the appeal as moot. I've been
on a number of them where we've done that.
Mm-hmm. Yeah, I can look into it and
might have some effect on mootness if that finding is going to be gone anyways. Same as a reversal.
Well, if that's the case, yes.
What's the current situation with the children?
Well, as far as I know, the children, so there's 5 children. The twins are in one foster care family. The oldest boy and the girl are in another foster care family who is willing to adopt. The youngest boy, effective tomorrow, is going to a foster care family that is willing to adopt. So it's just the twins that I don't know that the family's willing to adopt them, but the others, yes.
Thank you for that, Dave.
Thank you, Your Honor.
Case 143 in the matter of Anthony Crespbow versus Wynn. Counsel, proceed.
Good morning, Jonathan Garvin for Ms. Wynn. May it please the court. The family court's failure to conduct a searching inquiry and warn Ms. Wynn of the dangers and disadvantages of proceeding pro se was a denial of due process and deprived her of her fundamental right to counsel. This court is compelled to there's no harmless error analysis. That's entitled to a new hearing.
Just to be clear on that, this is not a situation where there was a government agency who was interfering with the family. There was no attorney on the other side of the case. What type of warning was required under those circumstances?
Okay, first of all, the ultimate result was that Ms. Wynn lost legal custody of her children.
Right. But in the context of this case, it was
there's no exception that I'm sorry. Go to your question. So you're asking what the searching inquiry is mandatory, and although there's no formal you're saying, what you have to be called like disadvantage.
The referee said there's counsel available. I'll give you the number, you can go and talk to the attorney if you want.
Well, in my brief, we cited cases where that was found to be insufficient, including Mercado versus Arzola, where the same situation, there was an advisement, you have the right to counsel. I'll provide you with the contact information of legal aid, and then there was no follow-up. And that was found to be insufficient.
The standard in family court is the same as in criminal court. If somebody wants to go pro se, there has to be a searching inquiry to advise the person of all the dangers and pitfalls. Really not a good idea. You didn't go to law school, do all these things. If the person insists, though, the court has to let them go pro se. Here, the court didn't do that first step in your view. Advise, say, hey, this really isn't a good idea for reasons A, B, C, and D.
Right. They didn't do disadvantages. They didn't do the pedigree information. They didn't inquire into what the Court of Appeals has said is the better practice to look into the age, do some type of inquiry. There was no inquiry at all. It's not like it wasn't adequate inquiry. This is no inquiry into the making awareness of how important it is to have an attorney.
So she wants a new hearing.
She wants a new hearing.
She did pretty well at this hearing. The only difference is really she still has joint custody. Shared residency, it looks like. The only difference is tiebreaker goes to the father if they can't agree. That's
significant when dealing with young kids that she's lost that ability to. First of all, no one was even whether it's a default judgment or not. There's got to be a sound and substantial basis on the record to justify a family court's decision. And even the father, before the hearing began, said, because there's joint custody and shared residency, that it should be equal. They should be equal say. There was no argument that AFC didn't take a position that there was something with the mother was doing something with a medical appointment or education or with extracurricular activity. There was no basis. I know I can't really get into the merits, but
Counselor, to follow up on Justice Sullivan's question, you want a new trial, but I think in the AFC in her brief said that your office had filed a modification petition and that a trial was scheduled to take place in December in this proceeding. Is that true? Has there been a new trial?
The new trial did not take place. What did happen is, and we wrote something up top that doesn't matter because that's an end run around the harmless error analysis, which you cannot conduct here. And there was no showing on the record. This is all off the record that she had a fundamental right to this appeal under CPL 5511. And if you're going to say there's a waive that she somehow waived that,
I'm not saying that. Just to be clear,
okay.
I'm just trying to understand. You're asking for a new trial, but if you're asking for a new trial, we would order a new trial, but it's already taken place. I'd like to know that.
Oh, the trial didn't take place. There was in June of 2025, the father filed a violation of a court order. And then both parties had crossed Article 6 petitions. That was scheduled to go to trial in December, but they did not take place. And but there was no.
Is it rescheduled?
No, it's not rescheduled. So there's no trial going to be taking place.
The petitions are still pending?
Petitions are not pending.
So it got dismissed?
It got dismissed. And my understanding is, and this is just my own investigation, that the mother was unable just to proceed just on the only issue that's on this appeal that could only happen is whether they would have joint say on education and all that. So
yeah, I'm not sure it would be, even if they did have a trial, I'm not sure it'd be moot because the mother would have to show change of circumstances between this order and that order. If we affirm, if it's reversed, she wouldn't have to show change of circumstances.
Right. So
it might not be moot anyways.
Right. So this court has said, and Court of Appeals has said that the denial of due process mandates a reversal without regards to the merits. And this is an end run to say that this is having another trial would be a merits. But since no one was arguing that she was had done anything to justify not having equal say in the child rearing decisions, and these are very young kids, having a new trial is very important. And she didn't waive her right to appeal, and she does want her appeal.
Thank you, counsel.
And I didn't fully answer your question about, I know that there was argument that that it's a very common practice. The type of inquiry here is common practice, and they were on equal footing because they both didn't have an attorney. And I would just cite the matter of Marlene H. versus Lauren D., where the same thing happened. There were two pro se attorneys, but there was no inquiry whatsoever, and the court reversed and sent a new hearing. So there's no exception. Just because the family court violate both their rights to counsel doesn't make it any better. It actually makes it twice as bad. If no further questions, I will rest my brief.
Thank you.
Hey, please the court. Maureen Poland from the Legal Aid Society of Rochester for the Children. I would just like to first address the trial that did not happen. And the reason that the trial did not happen on December 4th was because both parents, who were represented by counsel, the mother by the public defender's office, the father by the conflict defender's office, as well as an AFC from my office, they both chose to withdraw their petitions. They were on the cusp of going to a hearing. And after consulting with counsel, chose to not have a hearing, which respectfully, I would submit raises the question of whether the mother wants a hearing in this case or not. Because she could have had one in December.
No harm in reversing here if the law requires and giving her that opportunity again, right? Probably say, no, I'm good, according to you.
So, Your Honor, every time that a family has to go back to court, it's a disruption for that. It's a disruption for the children. And potentially here, the mother has decided she doesn't want to litigate this. The reality is custody cases are not criminal cases. You can actually end up in a worse situation after a modification or a new trial in a custody case than you were originally. As the court noted, she actually had a pretty good order here. It's a 223 order, joint custody, independent access. There is the final decision-making, which I understand the mother might disagree with, but then she should have gone forward with a trial in December to demonstrate why that was not in the children's best interest. She chose not to do that. So I appreciate that the court may feel like it needs to reverse given what occurred here, and I respect the court if it has to do that, but this is common.
Do you disagree with counsel's argument on what a court has to say before a client goes pro se in family court? Standard colloquy, is it the same as in criminal?
So I think case law says it's the same as criminal. I can tell you in practice, as an attorney who actually practices in family court, that does not occur. In particular in custody cases like this. So I have appeared almost daily in family court for a number of years. I now supervise attorneys who appear regularly in family court. I talk to them about what they're seeing. This is not uncommon. While I was writing this brief and trying to figure out what I was going to argue, I covered a first appearance for one of my staff attorneys, and the judge in that case gave a very similar, advisement of the right to counsel. I can give you the phone number to the PD's office. Do you want that? No. Are you going to represent yourself? Yes. And left it at that for the respondent mother. I went and talked to that judge after the fact because I was doing this appeal, and it's not good for families if we send things back to court when there's an order that seems to be working and they have to potentially litigate again. It's just simply not good for families. So I would, unless the court has I guess first I would note that the mother did not lose legal custody. She does still have joint custody here. But I would not characterize this as an end run around the harmless error analysis. Family court, again, is simply different than criminal cases. Until a child turns 18, we can go back and revisit what custody looks like, because we're going to be looking at what is in the children's best interests. So unless the court has any additional questions, I'll just rest on my brief.
Thank you, counsel.
Thank you.
Case 144, Morse versus Morse. Council Powers, can you hear us?
I can hear you. Can you hear me?
We can. And Council Alderman?
Yes, I can hear you, Your Honor.
Very good. Thank you. Please proceed, counsel.
Thank you. May it please the court. I'm Richard Alderman. I represent the defendant appellant, and the matter arises from a proceeding involving the custody and parenting time of two children of the parties. It's in context of a divorce action, and the ancillary economic issues had all been previously resolved through a separation agreement that the parties entered into. The trial before the court centered on the custody and parenting time of the two children.
Counselor, as you're reciting the procedural history here, let me start with a procedural question for you. The order that's on appeal appears to be an order that the court signed without there being an underlying motion. Do you agree with that?
Unless you consider the application a motion, it wasn't a formal motion. Yes, Your Honor, I would agree with that.
All right. So in that case, is that an appealable order?
Well, I think it resulted in an order. Whether the procedural prerequisites were appropriate or not, I would suggest that the order is the order. And the prior
I know this wasn't brief, but is there a pathway to appeal an order that, say, entered sua sponte by the court?
I did not research that, Your Honor, but my own sense would be that because it's an order, yes, it is an appealable order. It's not a decision, it is an order.
Well, I think we're talking about appealable as of right.
Yeah.
It may not be appealable as of right, but you could seek permission, or we could grant permission to hear it, even if it was not on motion.
Yeah. Well, as I say, I didn't research that issue, Your Honor, as to whether or not we need leave to appeal, because it was not generated by a formal motion. The prior order of the court, where the attorney for the children was appointed, specifically directed that the issue of compensation for the attorney for the children would be determined after the matter was resolved, and said that it be on 5 days' notice at the conclusion of the attorney for the children's services in the action or proceeding. And that was all in bold print. That was in two orders. The original order on March of 2022 and the amended order of April of 23. So that particular order, in effect, indicated that the attorney for the children only had to submit an application for fees, and then the parties, either the mother or the father, would have the right within 5 days to take issue with that. And of course, that was not provided to either of the two parents.
So, Counselor, you're taking issue with the amount of fees requested, the $28,537, or are you taking issue with the pro rata share, the 65-35 split from the court?
That would be both, Your Honor, and it would be
okay.
Yeah, it would be up to my client to decide which either or both of those issues were to be raised, because my understanding, and I think the court decisions support, that unless there's a stipulation between the parties involved, that the court has to allow a party to have a hearing. Or
Right. Well, there was a divorce action.
Yes.
Where child support was determined, other things. The pro rata contribution, the general child support obligation, uninsured medicals, so forth, was 60-40, was it not? 60-40 to the father, then the mother gets 40?
That, I believe, originated out of the separation agreement, Your Honor.
Right. So would you have any, are you saying the court should have gone 60-40? I mean, you want a hearing on pro rata, even though the whole issue of pro rata had already been litigated in the divorce action?
Well, in the divorce action, the pro rata was only with regard to the add-ons to the child support issue, Your Honor.
Right, but that's based on the parties, how much money they make.
That would have been at the time of the separation agreement, which took place in July of 2023. The final decision on the custody proceeding occurred on May of 24, and then the judgment of divorce was issued May of 24, and then the application for attorney's fees took place a month after that. So we're talking approximately 11 months after the agreement.
You want updated financials. You want a hearing on, has your income changed? Let's spend even more money litigating this bill. You want a hearing on all this all over again, send everyone back to court.
Well, that's up to my client, Your Honor, and he wasn't given an opportunity to make any determination, but he did decide that he wanted to proceed on this appeal to at least have that opportunity to decide if you wanted to raise the issue on the proportionate sharing of the AFC's fees, and or whether or not the fees that were being applied for were appropriate. So those are two issues that he didn't have the right to make any decision, and he's asking for that opportunity to make that decision.
Anything further, counsel?
Unless there's other questions, no, and I appreciate the court's attention. Thank you.
Thank you very much. Mr. Powers.
Good morning. Thank you. May it please the court. I am Chris Powers from Mackenzie Hughes Law Firm in Syracuse. I am appearing remotely today, so thank you to the court for allowing that shorter commute than usual is required. I represent respondent Julie Morse. We will primarily rely on our brief, but I just want to point out that hearing is not required in circumstances, which I think we mentioned in our brief pretty thoroughly, in circumstances where the judge can make an informed decision without an additional hearing, and I think that was the case here. I mean, there was 10 days of trial. The financial positions of the parties was well discussed, and referenced by the judge in her decision of divorce, which was only a month before this AFC fee issue became before the court. So and that request was supported by 40 plus pages of invoices and seems to be relatively well supported. And so I guess the bottom line is the judge was well equipped to make this decision, and without an additional hearing. I would also.
Do we know what the does the record indicate what the attorneys for the parents spent for this custody trial? How it compares to what the AFC charged?
I don't want
you to tell me if it's not inside the record, but I'd be just curious to see if there's a claim that the AFC overcharged at 28. I'd be curious as to what the other two attorneys charged.
I don't believe that's in the record, Your Honor, and so I'm not sure that I can answer that.
Okay.
The only other thing I want to point out, and then if there's any other questions, I'm happy to answer them, but just allocation was decided, in the initial order as we discussed, and at no point during, the pendency of this trial, which lasted, like I said, over the 10 hearings over several months, there was never an objection about that at the time when it was issued, at the time when it was any of the court appearances, at the time then the the appellant even actually paid. So that indicates that he didn't object to the payment allocation at that time either. And I think there's case law that says that if there's no objection, then he waives his right to a hearing. And I would just leave it at that unless there's any other questions.
No other questions, counsel. Thank you.
Thank you.
Good morning, Catherine Sullivan, attorney for the children in this matter. May it please the court. I would first of all agree with the assessment that no motion was filed in this case, even though it wasn't briefed or argued. It seems that the more appropriate avenue to object to this would have been by way of a motion to vacate, as opposed to proceeding with an appeal, presumably as of right. Additionally, it was asked whether the attorneys for the parents, if their fees were in line with or less than what was requested by the AFC. I don't have that information, but I do know that her fee was set when the statutory rate was only $75 an hour. And for the bulk of the appearances, the entire trial, motions, meeting with her clients repeatedly because of the mostly meritless arguments made by the appellant, she was paid at $8 below the statutory rate that AFCs were paid.
When you have private pay, because this was a private pay,
Right.
can the AFC on private pay charge their private practice rates, or are they limited to the 158 now that public AFCs get paid?
No, they don't get paid at their private pay rate. They get paid at what's set by the judge. I do some of those cases. I don't do a lot of them, but it's my experience that they're getting paid since the statutory increase to $158 per hour. They're getting paid at $250 per hour or $300 per hour. So I would argue that she was woefully underpaid.
Wait a minute. So if you're a private AFC, if you're an AFC and it's private pay
In a divorce case,
in a
private
divorce
pay.
case,
Private pay.
the AFC can get up to $300 an hour.
Yes, sir.
This AFC got 150.
Yes, sir.
Benefited everybody.
Except the AFC.
The AFC.
I would have made a motion to have my fee changed immediately as soon as that change was made.
The 28, I know you weren't the AFC below, but 28.5 seems reasonable.
It seems very reasonable, way more.
10-day trial.
Yeah,
prep.
absolutely. And I would hasten to estimate that the attorneys for the father and the attorneys for the mother probably charged at least 4 times more.
That's why I asked the question. I mean,
Yeah,
should
no,
AFC
can be
become
sure of that.
substandard compared to the parents?
Be sure of that, Your Honor. Thank you for asking that question. So I wanted to address appellant's reply brief in which it was argued that the children don't have a stake in this. As was stated by my colleague who argued the last case, every time the cases go to court, there's a disruption in the family. And my clients just want all of this litigation to be over. And as such, returning this for a hearing would not be in furtherance of those wishes or benefits. Additionally, if you change the allocation, or if not you, but the allocation is ultimately changed, it would presumably work against the mother and would lower the amount of the money that she has for their family, which is where my clients primarily live, to the benefit of the father, wherein that would go to his pot, which is just himself. So that is also an interest of my clients. I would also argue that this type of posture in this particular case, especially these arguments, is really adverse to the AFC program. If you take a zealous, as an AFC in a divorce case or any case, if you take a zealous, well, it would apply to a private pay case primarily. If you take a zealous position on behalf of your clients, you see them regularly because of the meritless arguments made by the one of the parents. You do a lot of research, you make a lot of filings, you attend a lot of court appearances, and then based on the objection of the parent, the same parent that argued against you, questioned your arguments throughout the entire case, attacked you throughout the entire case. If you reward that person by reducing the attorney's fees so that it's such that some of her time isn't even compensated, that is not a situation that.
So really, Counsel, what you're saying is if the AFC has to fight to get paid, they should get paid for the fight.
I would argue,
Right.
and I would argue that costs should be awarded for everybody here against the father. So, and then if we're going to send the case back for further hearing, I would posit that the rate should go up to the $200 or $300 rate, and the apportionment allocation between the parties should go less to father's favor as well. And I would also point out that it should be noted that the issue of attorney's fees was considered by the judge at the trial court level. In her decision, she awarded 10 hours of fees to the mother's attorney to be paid by the father because of his dilatory behaviors, his meritless arguments, and his prolonging of the litigation. So this issue has already been decided. So for so many reasons, the appeal by the appellant should be denied. So if you have no other questions, I would.
No questions, Counsel.
Thank you.
Case 145 in the matter of David Chun versus Kim Titron. Okay, we have you both, Counsel. Counsel, can you hear us?
Yes, can you hear me?
I can, thank you.
We all set?
Is it Mr. Pelch?
Yes.
Yeah, very good. I can hear you too. Very good. Let's proceed. Thank you.
Thank you. Peter DiGiorgio for the appellant. For the most part, I'm going to rely on my brief. This is a pretty straightforward family court modification appeal. I do want to comment on the preservation issue that was briefed by the attorney for the child in her second brief. I'll acknowledge that trial counsel did not make a motion to dismiss the petition at the conclusion of the petitioner's case for lack of a change in circumstances. And I don't know if I'm splitting hairs, but I'm sure you'll tell me if I am. But the court actually, in its decision at page 20 of the record, actually ruled that there was a significant change in circumstances. And I believe the appellant always has the ability to have the court look at, is there a sound and substantial basis for the court's findings? And one of the court's findings was that there was a significant change in circumstances. So I know there's case law out there that says that this issue has to be preserved, but I think when the court specifically rules on it, it automatically comes up for review under the sound and substantial clause that we all live with in family court. And I would argue that all of the proof that the father made in this case was not substantial enough to change anything. The order had not been that old, the prior order that was made on consent. He did disparage, my client did disparage him in text messages, but I think the father testified that 95 to 99% of the time that it was not while the boy was on the phone with his father.
I think one of the main complaints was the mother moving multiple times without informing the father of a new address, being hard to get a hold of. He couldn't even serve her with process here because he had no idea where she was living. And that doesn't seem consistent with a joint custodial arrangement, not to tell the co-parent where the child is.
I think, the court put a heavy emphasis on the inability to serve and her repeated requests to appear virtually. And And I don't think the record bores that out to be a substantial a part of the case. I think the court was upset with some of the language she was using and calling him names and the text messages. And I just don't know.
She moved 4 times in 6 months. Maybe that's not significant in and of itself, but as you say, I think that it was those text messages that were most concerning about her willingness to recognize the father as a parent of this child and to foster a relationship between the father and the child. That seemed to be the main sticking point for the court.
Right. And I think with respect to the move, the court didn't cite that in its findings. With respect to her, disparaging, the court commented on that. But again, without the boy hearing some of this or experiencing it, we're going to go down a slippery slope, having been in the pits of family court or the fighting pits of family court. If we're going to change orders based upon, some of the parties' activities in this regard, especially given the fact that this was only a several month order. The order had not been that old. So the last thing I want to comment on, it's really not part of the briefing, but the AFC withdrew her initial brief and substituted with a second brief based upon the changes of her client's position. And I understand her predicament, but I think it emphasizes that the court shouldn't put much deference on, and obviously I'm not privy to what occurred at the in-camera hearing. And this is why I think it's important for the court in all these custody cases, consider, with younger children, not to necessarily consider, their positions as that they flip-flop a lot, and it makes life very difficult for appellate attorneys when their position from the time that the decision was made in a given case changes when it comes time to, advocate on the appeal. So unless the court has questions, I'll rest on the 2 points in my brief.
Thank you, counsel. Counsel?
Good morning. Thomas Pelch for the respondent, David Chun. May it please the court. Because Mr. DeGiorgio was kind enough to mostly rely on his papers, I will mostly do the same and just address a couple of points that he raised in his oral arguments. First, there is no time component as far as when a parent can bring a modification petition. In this case, I would argue that it was necessary to come as soon as possible because the parental relationship was being alienated and isolated such that if he didn't move quickly, who knows what would have happened. Second, on the disparaging comments piece, the testimony is that the child is on the phone, disparages dad 5% of the time. And under the order, they're supposed to be having 2 calls a day. So I don't know what the math on that is, but 5% of the time of 2 daily calls, it's a lot of bad-mouthing dad to the child on the phone. And then lastly, on the moves, the issue with mom, other than from a stability perspective, wasn't that she had moved a number of times. Like, it's certainly reasonable given her circumstances that she may need to move for financial work, other reasons. The issue here is that she would never notify dad of the moves, and dad never knew where his child was residing. Dad also didn't have access to the child's medical, dental, school records, as well as social security numbers, things like that. So I would just argue that the record, by a sound and substantial basis, more than proves both the change in circumstances and the best interests, and that the court look at this from a totality of the circumstances where it was the mother's cumulative effect of alienation, blocking contact, disparaging the father, all these things combined. And from a best interest perspective, the dad is really the only parent in this situation that would be able to foster a relationship with the other parent moving forward. So perhaps the best interest, I don't know how all the factors turn out, but I think that one issue is probably dispositive in this case because he's clearly the only one who's willing to foster a relationship with the child and the other parent. So unless there are any other questions, I'm happy to rest on that.
Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the court. Susan Meredith for the child who is now about 8.5 years old and is in the 3rd grade. Regarding the preservation issue, I think Torres v. Burchell is directly on point. I think that case, the court also found a change in circumstances, but this court found that that issue was raised for the first time on appeal and not preserved.
If the court rules on it, then it's before us. In other words, the whole idea of an objection is to alert the court to an error, so the court can make a ruling. If the court makes a ruling, then we have to address that. But can I ask you about the Michael B. allegations that you raised in your first brief? It was supplemented. You have a supplemental brief. In your first brief, and I assume that your child's position changed, and so your position changed, you're advocating. But in that September 30th brief of 2025, you provided us with information pursuant to the Court of Appeals case Michael B., which allows us to consider evidence that occurred after entry of the custody order. In that brief, there's some indication here that, according to the child, there are rats in his father's house. The grandmother stomps on them, the father cooks them, and they eat them. There's also concern about the child sleeps in the living room, it's cluttered, he doesn't have enough food to eat. Those allegations don't appear in your most recent brief, but can we just ignore those, ignore what you said first? And are those conditions still present?
I don't think so. So to address all of that, when I first met with the child, that's what he told me. And he also told me he wanted to live with his mother. When I met with him a second time after seeing a recent photograph of his bedroom, he was no longer sleeping in the living room. He was sleeping in a nice bedroom. When I specifically asked him about the rats, he said that wasn't true. So
he was, I don't want to say lying, but his information to you the first time was not correct?
According to him, yes. Frankly, I think the child has been coached by each parent. So originally it was probably his mother's coaching, and now it's probably his father's coaching. But I'm going with what he's telling me. He's sleeping in a nice bedroom. He said the rats weren't true. He specifically told me the food he likes to eat, that his grandmother cooks, which is a Vietnamese dish. So he pretty much recanted that they were eating rats. So
if any of this is true, if the mother believes it's true, she could file a modification petition.
Which she did, and then which was in my first brief, because the mother said the living conditions were not good. And then the father filed something else, and everybody withdrew their petitions. As far as I know, the update I got, there have been no subsequent filings.
How's he doing in school and elsewhere?
He's doing great in school. He seems happy. He told me when I asked him how he's doing, he said great, which he didn't say the first time. And just by his demeanor, the first time he seemed sad. The second time I met him, he seemed like a typical kid, happy doing what he's doing.
Any further, counsel?
Unless there's any questions, I'll rest on my brief.
No questions, counsel.
Thank you.
Case 146, Federal National Mortgage Association versus Buchek.
We're just going to wait for the attorney who's on the other side appearing remotely, and we haven't seen him yet.
Let me just get my pen to it.
Sure.
Judge, we have him on the line. It's just taking an extra moment to bring him over.
Okay. Thank you. Yeah. Justice Wayland, we need not wait. He will be back momentarily if that's what the wait is.
It appears just to be a technical issue on the attorney's side. We have him on audio, Judge.
All right. Audio, no
Can you hear
video.
me?
Yes, we can hear you. Can you hear us?
Yes, I apologize for the technical issues.
That's fine. As long as you can hear us and vice versa, we will proceed. Ms. Buchek, it is your appeal and you may go forward.
Yes. Good afternoon, Your Honors. If it may please the court, I am Deborah Buchek, appearing as pro se as the appellant in this appeal from the Erie County Supreme Court order dated August 22nd, 2024, in the matter of Federal National Mortgage Association versus Deborah Buchek and others, Erie County Index Number 808135-2015. Your Honors, this foreclosure proceeding is legally void from its inception and must be reversed in its entirety. The most serious defect in this respondent's counsel made materially false statements in its brief. Counsel asserted, and I quote, "In fact, in 2018, the lower court granted a motion to, among other things, amend the caption and substitute respondent Federal National Mortgage Association as plaintiff. The prior plaintiff had filed and served that motion, which attached documents proving assignment of the mortgage and possession of the note."
Ms. Buchek,
Yes, Your Honor.
just want to make sure I understand the background facts. We have a lot of these cases. Just correct me if I'm wrong. So you took out a mortgage in 1994, borrowed money. You defaulted on that mortgage on March 1st, 2014. That was your last payment?
Yes,
So that is what, 12 years ago?
yes, Your Honor.
Have you made any payments over the course of the last 12 years?
No, Your Honor. It was, I didn't know who to make it to. They didn't have
Right, all right.
title.
So no, how long, are you still living there now?
Yes, I am, Your Honor.
16 years later, you're still there?
Yes, Your Honor.
And you paid not a penny? I'm just trying to establish background facts. All right,
Yes.
so you've been living rent free. What about the property taxes?
I've paid them, but during this procedure, we have not paid them.
So you haven't paid in 12 years?
Correct. I believe it's
So-
11 years.
11, okay, so 12 years, you're just living there, zero expenses?
Yes, Your Honor.
All right, and you want to continue staying with zero expenses?
Well, we would like to.
We
get
rule
all
for you.
property.
Yeah, if we rule for you, you get to stay. All right. So those are the background facts, and your issue is with respect, your first legal issue, you may continue. I interrupted you.
Okay, thank you, Your Honor. Okay, see where it was here. This representation is false. I have personally reviewed complete. Someone speak? Okay. I have personally reviewed the complete Erie County Supreme Court docket under index number 808135-2015. And there is no 2018 notice of motion of affidavit of service upon me, no motion papers, no supporting exhibits, no order with Federal Mortgage Association as plaintiff. None of these documents exist in the record. This continues fraud upon the court in violation of Judiciary Law, Section 487. It also violates Rule 3.3A1 and 8.4C and D of New York Rules of Professional Conduct, 22 New York CRR Section 1200.0. New York courts have imposed severe discipline, including disbarment, and precisely this type of intentional misrepresentation to the tribunal. I respectfully request that this court order Respondent's Counsel to produce certified copies of the purported 2018 motion papers and resulting order within 10 days. Should counsel be able to do so, as they did not exist, I ask the court to strike these false statements from the respondent's brief, vacate every order that relies upon the pursuant to CPLR 50, 5015A3 and refer counsel to the appropriate attorney grievance committee for investigation and discipline. Even setting aside this fraud, Federal National Mortgage Association was never properly substituted as a party to this action. A court cannot simply amend caption years later and retroactively confer standing upon non-party. Proper substitution of the plaintiff requires a formal notion on notice supported by complete evidence under the CPRL 1018 period. Nation
All
Star.
right, yeah, I think we get the gist of it. And you want us to dismiss the foreclosure action. You can continue in the property. Do you have to pay going forward, or can you stay for free for another?
We want to get title of the property.
What's that?
We're trying to get title of the property.
I thought you were living in the property now.
We are living in the property,
Okay,
but there's a foreclosure.
right.
Trying to take.
So what would happen with the money that you owe?
What would happen with the money that I owe?
Yeah, would you start making the payments going forward?
There is no money that is owed to the property.
Oh, okay,
If I may proceed.
sure.
Thank you. Proper substitution of plaintiffs requires a formal motion of notice supported by complete evidence under the CPLR 1018 Nation Star Mortgage LLC versus Gunwall 2003 AD 3D 11700 2D Department 2022 Brighton Bank LLC versus Prabansky 131 AD 1,000 2D Department 2015 and this court's own president in NNPL Trust Series 2012 versus Lynn 149 AD 3D 152 Fourth Department 2017. Without such substitution, Federal National Mortgage Association any authority to seek foreclosure relief. On standing must at the time the complaint is filed. The original plaintiff has required to demonstrate possession of the note or valid commencement written assignment. A mortgage only assignment is insufficient. Bank of New York versus Silverberg 86 AD 3D 274 2D Department 2011. Post-commencement assignments cannot be cured to defect. Wells Fargo Bank, NA versus Marchon 69 AD 3D 204 2D Department 2009. The record contains no admissible proof that the original plaintiff possessed the note when this action was commenced. Standing is not waivable in residential foreclosure cases. RPAPL section 13028. The mandatory RPAPL subsequent was also ignored. There was no proper order of reference under RPAPL section 1321. No confirmed referee's confusion, no valid judgment of foreclosure and sale under section 1351, and no proper notice of sale in section 231. Necessary parties were never joined as required by RPAPL section 1311 and CPLR 1001.
Ms. Buchek, your time is expiring, so you should wrap up.
I just got like one little paragraph and I'll be finished.
Very good. Proceed.
Thank you very much.
Yep.
I'm so dry. I'm sorry.
We can get you some water, Chris. Is there some water?
It's hard to speak on it because I'm nervous or something. I'm not an attorney here. I didn't even see that, but thank you. I don't want to take your time.
Nope.
It's perfect. So much better. Okay. The necessary parties were never joined as required by RPAL Section 1311 and CPL 11001. The omission renders any judgment in subsequent sale void as to these parties. Polish National Alliance versus White Eagle Hall, 98AD 2D 4002D, Department 1983. Finally, the statute of limitations expires 6 years after acceleration under CPLR 2134. A transfer of title does not reset the clock. For these reasons, I respectfully request that this court reverse the August 29, 2024 order in its entirety, vacate the judgment of foreclosure and sale, and declare March 1st, 2024 notice of entirety nullity. On demand, the Supreme Court should be directed to deny any application to amend the caption or substitute plaintiff absent a proper CPLR 1018 motion is admissible proof of no transfer, required strict compliance with all RPAPL provisions, order of the joiner of all necessary parties, and dismisses action in standing or statute of limitations defects are confirmed. I also respectfully request an award of costs and imposition of sanctions against respondents pursuant to 22 New York CRR 13011. Thank you, Your Honors, for
Very
letting
good.
me go a little bit.
If you have a seat there while your opponent argues.
Yes, thank you very much.
Very good. Mr. Kaufman, are you there?
Yes, may it please the court, Harold Kaufman from McCalla Raymer, Liebert Pierce LLP, on behalf of plaintiff respondent. I will mostly rest on my brief, which deals with these issues, but as to the issue raised in appellant's argument that my papers are incorrect in stating that there was a motion to amend the caption to name Fannie Mae and that there was no order granted in 2018 to amend the caption, I would direct the court first to the document beginning at the record on 61 to 65, which grants the motion to amend the caption. I would also direct the court to the affirmation of Ms. Buchstaver, which was filed in 2017, which sought, among other things, for an order amending the caption. The caption has been amended since the March 15th, 2018 order. The amended order of reference, is captioned by Fannie Mae. This has been the case for 6 years. I would also note that appellant filed 2 subsequent appeals, but never perfected them. Therefore, under Bray v. Cox, she's barred from raising these issues on this appeal. I would also note that she did not appeal from anything having to do with the statute of limitations. For all of those reasons and the reasons set forth in my brief, we ask that the court affirm the August 22nd, 2024 order. And if the court has no further questions, I will rest on my papers.
Very good. Thank you, counsel.
Thank you.
Case 149, Bankers Healthcare Group LLC versus Genevieve. Counsel, there you are. Can you hear us?
Yes, I can, Your Honor. Can you hear me?
We can hear you loud and clear.
Great, thank
Okay,
you.
very good. Please proceed.
Thank you, Your Honors. May it please the court, I'm Anthony Pietroface. I represent Dinah Geneve, who's also known as Margaret Geneve, and note that I may refer to her by name and also refer to the respondent as either Bankers Healthcare Group or BHG. I think one of the great things about being, or one of the things being this part of your calendar is that I probably have a lot less to say than I did 2 hours ago. So I'll try to be brief. I want to make just a couple points. First, as you see in the papers below, the parties agree that Florida law governs this action. And that said, although we spent a lot of time analyzing the Florida long arm statute, I think if you take a step back, you realize this is really a matter of contract law. And we submit, as we have in our brief, that the court below erred by applying New York law. The question as we pose to you is whether a non-resident can waive jurisdiction by virtue of a contract. Now, New York, as the court below noted, will accept a contractual waiver in derogation of CPLR 302. Florida, however, takes a different position. It may be a minority position, but since Florida law governs the financing agreement between the parties, it is crucial. And we note that Florida Supreme Court, in the case of McCrae versus JD/MD, which we cite in our brief, has ruled that although the parties are free to contract as they wish, a non-resident does not waive jurisdiction with a simple contractual provision. Now, Florida does recognize, as New York does, the right of parties to negotiate a forum clause, and that was recognized in the Florida Supreme Court case of Enrique versus Febri, which is Febbri. It's a case respondent cited below. But the court in McCrae distinguished Enrique by saying Florida doesn't recognize forum clauses to the exclusion of its long-arm statute. So and this is, again, a matter of contractual interpretation. So we believe the court erred by simply relying on New York law. Now, second, we think the court erred by presuming that there was a clear consent here. The court did not analyze the relevant provisions. There is a venue clause in which it identifies 4 places that BHG prefers for trial. But venue does not precede jurisdiction, it follows jurisdiction. So here the operative sentence is, and I quote, "Debtor agrees to submit to the personal jurisdiction of the appropriate court in the state of New York, Onondaga County, or state of Florida, Broward County." Now that's not express, it's not unequivocal, it's not mandatory, it's really a qualified consent. Who decides whether the form that BHG chooses to sue a defendant is a quote-unquote appropriate form? It's the debtor. So Dinah Geneve was properly exercised her rights under the agreement to contest jurisdiction, and we believe it was error for the court to overlook the precise language here. Now, if you get to the error question of jurisdiction, either through using the Florida law or finding that there was no real waiver, you're left with an analysis of the jurisdiction, and here the facts were undisputed by the respondent is that BHG is a Florida company, Geneve is a Florida resident. All the acts complained of happened in Florida. The money was dispersed and used in Florida, and the cause of action arose in Florida. There's nothing, in other words, in the complaint or in the record that alleges Geneve acted in New York in any of the prescribed ways of either the Florida long-arm statute or CPLR 302. And I note that we briefed both of those statutes for the court below, and those memorandums are in the record before you. Also, there's nothing in the record that says that Geneve had any other minimum contacts with New York sufficient to satisfy constitutional concerns. So for those reasons, we believe the decision should be reversed and the action dismissed. And I just want to make one final point, and that's the court below and the respondent rely heavily on a case by this court entitled Bankers Healthcare Group versus Passenball. And we submit reliance on this decision is misplaced. The question before the Passenball court, in fact, as put to this court by BHG itself, involved only the choice of law provision. The question was whether the phrase construed and governed by the substantive and procedure laws of the state of Florida required a New York court, otherwise having jurisdiction, to apply the Florida rules of civil procedure. BHG did not ask the court to rule on the form sentence, and this court did not enforce it as we read the decision. And this has caused some confusion in the 5th District as to Passenball's scope, so we hope the court will take this opportunity to dispel the confusion in limiting Passenball's authority to the choice of law section only. Thank you.
Thank you, counsel.
Good afternoon, may it please the court, Jordan Pavis on behalf of the respondent. I'd like to start with an irrefutable fact. Neither the appellant nor we, nor are we aware of any single case which exists in New York that uses the long arm statute of some other jurisdiction to determine whether a New York court has personal jurisdiction over a defendant. As far as we know, it's never been done. It's a novel theory.
Could the parties agree to that in the contract? We'll agree to use the long arm jurisdiction of X state?
No.
No, they can.
The Court of Appeals cases are very clear on this, Justice Lindley. I'll quote from a couple because I think they're directly germane to this issue. The case of Tanges versus Heidelberg, Court of Appeals case out of 1999. Quote, matters of procedure are governed by the law of the forum. On the other hand, matters of substantive law fall within the course charted by the choice of law analysis. In Martin versus Dirk Equipment, another Court of Appeals case, quote, matters of procedure are governed by the law of the forum. That's it. That's as black and white as it gets. Regardless of what might be in the contract, a New York court cannot transform itself into a Florida court. We're here under the appellate division rules of New York State, not the appellate division rules of Florida. When the appellant filed the motion to dismiss below, what did they cite in their notice of motion? CPLR 3211. There's no other way that a case can be processed and proceed in New York other than using New York procedural law.
You can't commence an action in New York using Florida, their version of the CPLR.
You cannot.
That seemed to be, what's your reading of our decision in the Passable case? There's 3 of us, 5 are on that, and that's being interpreted as a green light for what's going on here. Is this case any different from that case?
It's different in some ways, and it's very similar in others. The most similarity is that the financing agreement, the venue jurisdiction clause, was identical in that one as it is in this one. So however the court construed that provision there, it needs to be construed the same way here. It's true that that case dealt with choice of law, but also within that passable decision, it expressly said that that case could proceed in Onondaga County because the parties directly contracted for that to happen. That is a holding that forum selection clause is enforceable. That's my reading of passable. And many cases have relied on that decision from 3 years ago, which are commenced in Onondaga County and proceed, to this day.
Is it true that most of these choice of law provisions, talking about the substantive laws of the other state, are going to apply? This, as in our prior case Passable, the clause seems a little unusual in that it says the substantive and procedural laws of the other state are going to apply. That throws a little wrinkle. That confused us then, and it confuses me now.
I understand, and that's, I think, why we're here. But we can't change the language of the contract, and there's plenty of contracts that have been signed years ago with that language, and it takes a while for them to get into court. So we're kind of still addressing that language. Regardless of what the contract says, the parties cannot agree for some other state's procedural laws to govern litigation in New York, in Onondaga County. When you, and we went over this exhaustively in our brief, but when you file a lawsuit in Onondaga County, the county clerk processes it and charges a fee pursuant to the CPLR. Everything is governed by New York procedural rules.
You do it with substantive law, right? You can apply in other states without trouble. It causes hassle for us up here. We got to go on Westlaw and change a search to Florida or wherever, but it's feasible. Procedurally, not feasible.
That's exactly how it works, Justice Lindley. And, procedure law is essentially access to the courthouse, right? Statute of limitations, personal jurisdiction. That's got to be New York law. That's the only way it can work. And the Court of Appeals is very clear on that. And that's binding here. Substantive law deals with, what are the elements of a breach of contract? What are the enforceable interest rates? Things like that. That's substantive. And Florida substantive law applies. And actually, if you look at the Passable case, this court spoke to that. And it ruled that, typically procedural laws of New York apply, substantive laws pursuant to the choice of law clause are enforced. So here that would mean New York procedural law, Florida substantive law. That's one way we get to personal jurisdiction here, that the defendant expressly consented to personal jurisdiction, and opposing counsel has said, well, the word appropriate was in there. That was a qualifier. What he left out was that in the same clause, it gives sole discretion to Bankers Healthcare Group to choose the forum. So after they've got sole discretion to choose the forum, then it says they can decide where the appropriate court is, Onondaga County or Florida. So it's completely within their discretion. And there was
BHG has an office in Syracuse downtown.
They do. They have their financial headquarters. It's a substantial facility right at 201 Solar Street. And we've cited in the record, if you look at record page 71, 75, and 80 through 84.
So it's not like the plaintiff, and you see some cases, the plaintiffs will go and search the most favorable laws anywhere in the United States and say, this is where we want to sue.
Right.
Nobody has any connection. You're saying that's not, there's a reason for Onondaga.
That's not what's going on here at all. Bankers Healthcare Group has its financial headquarters in Syracuse. That's the reason, for efficiency and judicial economy's sake, that they file their collection actions in Onondaga County so that they can all be uniformly administered. And this is not like, to your point, Justice Lindley, this is not like a company decided to file all their actions in South Dakota because they've got more favorable treatment of creditors. Bankers Healthcare Group, and this is an independent basis for personal jurisdiction under CPLR 3021. The defendant did business with Bankers Healthcare Group, which has its financial headquarters in Syracuse.
This is a little bit off base, kind of, I'm retracing some steps, so forgive me for taking you back, but the language of the contract does say that procedural law of Florida will apply as well as substantive.
Yes.
And we're supposed to give meaning to contracts, right? So what meaning do you give to that phrase, procedural law of Florida?
It speaks for itself. However, it's not.
I need a little help.
Okay, it's not workable and it's not enforceable in New York. And for that and that's clear based on the cases. And the Court of Appeal.
Read that out of the contract for you to prevail.
Yes, if we're applying New York procedural law, which we advocate should be applied. However, there is an argument that even under the Florida long-arm statute that we have personal jurisdiction. We just haven't delved too far into that because it's such a black and white decisional rule that New York procedural law has to apply to a case in New York.
If there was a Florida statute, maybe there isn't, I just didn't catch it. If there's a Florida statute that says under no circumstances can a resident of our state consent to personal jurisdiction in any other state. If there was, just make up that statute. Would that be a procedural statute that New York would be required to apply under the provision that you've got? In other words, that would be a way of maybe giving it meaning. Perhaps I'm off base. If I am, it's okay to tell me in a nice way.
I would never tell you that, Justice, and I don't think that anyways. It's an interesting hypothetical. There's no provision like that I'm aware of. And
well, would that be a procedural concept that could be?
I suppose so, because personal jurisdiction, I think, is fundamentally procedural. It's not substantive. However, the statute doesn't exist. If we look at the New York statute and the decisional law in New York, they enforce consent to personal jurisdiction clauses, and we have that expressly here. So I've gone over that. I've gone over the independent basis that BHD has their financial headquarters in Syracuse, and that meets the long arm statute standard in New York. But there's a third one that we haven't spent as much time on, but it's the basis of the decision below. Justice Antonacci cited a second department case, the Oak Rock case, which said a forum selection clause automatically confers personal jurisdiction. And he looked at the Oak Rock case and he looked at the Passenbull case and he said, Passenbull, in his reading, enforced the forum selection clause. It said you can proceed with cases in Onondaga County. Therefore, because the forum selection clause is enforceable, personal jurisdiction is automatic. Even if we didn't have the express consent to personal jurisdiction, the forum selection clause, we know from passable, it's identical. It's enforceable. I don't know of a case in the Fourth Department that has expressly held that. But there's cases out of the Second Department and there's cases out of the First Department that have held that. And I just want to quote one out of the First Department. Sterling National Bank versus Eastern Shipping says, quote, the very point of forum selection clauses which render the designated forum convenient as a matter of law is to avoid litigation over personal jurisdiction, as well as disputes arising over the application of the long arm statute. Could that be more on point? It's directly applicable here. It makes eminent sense for a forum selection clause to automatically confer personal jurisdiction over the party that agreed to it. Otherwise, it hollows out that clause.
Right. I guess the other side of the coin of the question was a very good one by Justice Curran is what meaning do we give to the phrase the procedural laws of Florida apply? The other side of that is we have to give meaning to choice of law provision. And if we say, well, the procedures of Florida are going to apply, then there's no choice of law. You can't commence something in New York without using the CPLR.
Yeah, thank you, Justice Lindley, and maybe you articulated better than I did. I mean, the Passable case expressly held that BHG could file these cases in Onondaga County. If you hold that the Florida procedural laws apply, then they can. You're essentially abrogating Passable and saying, you know, we're going to enforce that the Florida procedural laws apply. And then when a case is pending in Onondaga County, we'll be back to the Passable decision, again from Judge Antonacci, which was ultimately reversed by this court. He said, well, the Florida procedural laws apply, therefore you can't file a motion here. I can't grant you any relief. I can only operate under the CPLR. The rule based on Passable is that New York CPLR has to be used for procedural issues. The forum selection clause is enforceable. And we argue in this appeal that this is an opportunity for the Fourth Department to find that a forum selection clause automatically confers personal jurisdiction.
Anything further, counsel?
No, Your Honor. Thank you very much.
Thank you. Case 150, Varma versus Allstate Insurance Company.
Justice,
Well,
can you?
hold on a second. Mr. Stacker, can you hear us?
I can hear you. Can you hear me?
We can, very well. Mr. Marcus, we can't see you.
Your Honor, I'm trying to get my video settings on here.
While you're working on it, let me check with Mr. McCaffrey. Mr. McCaffrey, can you hear us?
Yes, I can, Your Honor. Good afternoon.
Yep. And we can hear you too. Okay, very good. Mr. Marcus, why don't you continue to work on your screen? And Mr. Stacker, proceed.
Thank you. Good afternoon, Justices. After 35 years from graduating the beloved University of Buffalo Law School, first time being referred to as a maladroit. Since I'm a public school kid, I had to look up that. I want to be brief here. The first action in the lower court only addressed whether the insurance company could terminate the agency without cause. The lower court shut down any issues arising regarding compensation or termination payment. the lower court says it wasn't ripe. So at this point in time, in order to apply the judicial test on collateral estoppel, was there a full and fair opportunity to litigate that matter? The answer would be no, there wasn't. The court didn't allow us. So collateral estoppel doesn't apply. Lastly, I just want to say, since it's a question of law of whether this payment is a penalty and enforceable, I do believe, given the low dollar amount, especially after she was risen to the second highest sales level and produced $8 million in revenue for the company, that this should be determined by this court as unconscionable and struck down. And any questions from the court, I'd be glad to entertain.
No questions, counsel. Thank you. Mr. Marcus?
Your Honor, David Marcus for Wayne Levan. I will rest on my brief other than to say that any allegations against Mr. Levan are non-existent. The claims are against Allstate, and Mr. Levan sold his book of business in 2020. And what Mr. Stocker and plaintiff are arguing is that events that occurred after she was terminated by Allstate are what's in play here. There was nothing. My client had no involvement with Allstate. He was an independent contractor for Allstate. He had no involvement with Allstate post sale of his book of business, and there were no allegations made against him individually in the second complaint. Any allegations made in the first complaint were admitted by Ms. Varma that they were without cause. So she acknowledged that she did due diligence, that she verified the price of the book of business, and that she actually excelled beyond what Mr. Levan had done. So there really is no claims against Mr. Levan here. The rest, I will rest on my brief. Thank you, Your Honors.
Thank you, counsel. Mr. McCaffrey.
Yes, good afternoon, Your Honors. May it please the court, Kevin McCaffrey for Allstate. I don't have too much to add. I mean, I will say I think Supreme Court actually summed it up best in the order appealed. Quote, contrary to the arguments made by the plaintiffs, you cannot now raise the same issues and expect a different result. Close quote. And, you know, I think it's important to recall that there was a full evidentiary hearing that took place prior to the dismissal. This wasn't simply a motion. And the appellant and all parties were given ample opportunity to present any and all evidence. They all did. And the result was a dismissal. And one can't get around that by employing creative pleading and simply pleading new theories of liability after the fact. And that's because
Mr. McCaffrey, Mr. Stocker is not saying that this is liability. He's saying this is damages. That this termination payment arose. It wasn't ripe yet. It arose after the determination in the first case, and that's why it's not subject to res judicata. You wish to be heard on that?
Sure, Your Honor. The fact of the matter is you can't just simply reframe the issue as a liquidated damage dispute and take issue with the damages. Again, it's a transactional analysis in New York. It's not whether you've pleaded it or dealt with it before. It's whether or not, and look, I think the best way to deal with it is just to simply look at the Court of Appeals decision in Parker v. Blauvelt Volunteer Fire. I'll quick quote, where a plaintiff in a later action brings a claim for damages that could have been presented in a prior proceeding against the same party based on the same harm arising out of the same or related facts, the claim is barred by res judicata. That's the answer to that question right there, Your Honor.
Right. So res judicata includes not just claims that were litigated, but claims that were not litigated but could have been litigated in the first action. You think this TPP payment, this termination payment, it was known at the time how much he was getting, and he could have raised that and argued that he got a ruling on that in the first action?
Exactly, Your Honor. I couldn't have said better. And the last thing I would add, again, unless the court has questions, to the argument that claims that were disallowed were not adjudicated. The law is clear on that as well. And I've referred the court to a decision from this court just 3 years ago, Brown v. Erie Insurance Co. Quote, the proposed amendment is it's essentially clear where leave to amend is denied, it is because the amendment is found lacking in merit. So that's also disposed of. You can't go back and relitigate that again. And I would remind the court, this case has been dismissed 3 times now, twice in the merits and once for failure to perfect an appeal. So, at this point, I think we've had more than enough bites at the apple. Simply reframing the issue as a liquidated damages problem is not going to get it past the res judicata bar.
Thank you, counsel.
Thank you very much, Your Honors.
Case 148, Boozer versus Fine. Justice Del Conte is recused from this case. Proceed, counsel.
Good afternoon. May it please the court. My name is Elizabeth Cade and I represent the appellant Floyd Van Hooser. The main issue presented by this appeal is the meaning of a single phrase in New York's Adult Survivors Act, conduct which would constitute a sexual offense as defined in Article 130 of the Penal Law. New York courts have already interpreted identical language in another statute, the Child Victims Act, in a way that would revive appellant's claim in this matter. And the parties are in agreement that the court can look to cases interpreting the Child Victims Act and interpreting the same language in the Adult Survivors Act. These cases are Anonymous versus Castagnola, Doe versus Wilhelmina Models, SR versus Gates Chile Board of Education, and Doe versus Syracuse. These courts all held that the identical language in the CVA, the Child Victims Act, refers to conduct that is described in Penal Law, Article 130, but doesn't require allegations sufficient to establish criminal liability. Appellant is not asking this court to make new law. Rather, he's asking this court to follow reasoning of these decisions in interpreting this phrase of the ASA according to its plain language, and this would let appellant's claims proceed to discovery.
But the plaintiff still has to allege conduct that would, if true, show there was no consent.
That's right, Your Honor.
So we have to look at the complaint. We did this in Druger. Some of us were on that case versus Syracuse. And so the allegations here, we have to accept them as true, liberally construe them, give them the benefit of every doubt. So what allegations in the complaint here show that the 53-year-old plaintiff, there's no allegations of forcible compulsion. There's no allegations that he was physically helpless due to drugs or intoxication. So it seems like the allegations are saying that your client was sexually abused as a child, as a minor, by Mr. Fine. And then 30, 40 years later, he's so influenced by that. And there's this power differential that he can't consent. Those are the allegations, right? That's the theory. Psychologically, he can't say no because he's dependent on her for money now and he remembers what happened in the past.
That's not exactly the theory, Your Honor, but I'm glad that you brought that up because it is a good point. He does have to allege lack of consent, and he did allege lack of consent. So both if you look at our penal law, section 130.052C, which is any circumstances in which the victim does not expressly or impliedly consent to the conduct, and under a theory that's grounded in other sources of law, the restatement of intentional torts, these are tort claims, right? And the restatement of intentional torts, restatement third of intentional torts, section 15, it says that, you can look to a relationship of, let's say, a high school teacher to a high school student, right? And you can say that even if that student, it was 17, above the age of consent or at the age of consent, and even if that student does consent, there's something about that relationship that's inherently coercive, okay? So in that illustration, in that comment, it's comment D, I'm sorry, section 18, illustration 7 talks about the relationship of a high school student to a teacher, and that relationship is inherently coercive, right? So even if there's actual consent, it's actual consent induced by duress, and therefore it's not valid consent. The restatement third of intentional tort, section 15, comment D, the restatement says you can look to the history of the victims related, or the two parties engaging in the sexual conduct. That's a valid consideration in determining whether there's actual consent. And that's what the appellant is asking the court to do here. The appellant laid out in the complaint, and they meant a complaint, the history of his interactions with respondent Fine, that he was his foster child. There was very violent and horrific sexual abuse that took place over many years. And certainly there was a time period that he didn't actually see respondent Fine, although he says that they did remain in contact. So that relationship was continuing.
35, 40 years break with no in-person contact. But is this similar to an employer-employee situation where two adults, the boss, if you would, courses, encourage a sexual relationship with a subordinate? It's not rape because the subordinate agrees to it, but there's advancements and money and raises and not getting fired. This sounds like it's similar to that. It's same type of lack of consent.
It's not similar to a situation like that, respectfully, Your Honor, because this is a far more complicated, damaging, and really complex history, as opposed to two consenting adults where you have an employment relationship, and certainly there's a power differential there. But appellant is not saying that there can't be valid consent in any sexual relationship where there's a power differential. That's not what we're saying. Certainly consent can be found in certain situations where there is a power differential. What he's saying is that you have to look at his specific allegations in the complaint, which can be found in the record between R68 and 84, that he was sexually assaulted and raped as an adult, that he was afraid of this person because of their violent history, the violent abusive history, and that they remained in contact over that 35 or so year period of time. And because of this history, he lacked the capacity to consent to the sexual conduct as an adult.
Counsel, let me interrupt you for just a second.
Sure.
So the argument is, by looking at these factual allegations in the complaint and assuming they're true, which we have to do in a 3211, right? And giving every favorable inference. Your argument seems to be that based upon what happened to the plaintiff as a young person in unusual circumstances, I mean, he's a foster child and in the house, and it's over a period of time, and that you don't have to put forth any proof at this point. You just have to make the allegation at this point that there was damage caused there that translated years later, decades later, to this power differential. It continued, even though there was a gap. It continued because the psyche remembers things, right? And your argument is, because it continued, that power differential existed as an adult based upon what happened as a child and based upon the financial and employment relationship that existed between Fine and the plaintiff. And those allegations are all you need to do to get past this stage, this pleading stage, and a motion to dismiss.
Well, that's correct, Your Honor, because the plaintiff is not required to put forth proof at the pleading stage, and to hold otherwise would subvert long-standing precedent that the plaintiff doesn't have to offer proof at the pleading stage. And certainly, Your Honor picked up on a very significant part of the standard of review here, or the standard under which the court must decide whether the complaint can proceed to discovery, which is the court has to draw all reasonable inferences from the allegations in the amended complaint in the appellant's favor. And so would the reasonable inference from all the allegations in the amended complaint be that an adult who was horrifically sexually abused by his former foster father, then somehow that past was erased and he was able to relate to this person as an adult in a normal way that another adult who didn't have a history with this person would be able to relate to him. That's not what the reasonable inferences point to. It points to that the history followed him, right, through his entire life. The effects of the childhood sexual abuse, whether it be post-traumatic stress disorder, hypervigilance, or any of the many dynamics that will be explained at trial through
In other
expert.
words, let me just stop for a second. In a circumstance where there's a child raised by a mother and father in a setting, you know, just a child who's raised, you're saying that experience of being raised by this adult, when you get to be both adults at an older age, you're not two separate adults without a history. You're a father and a son, still, no matter how old you are.
That's correct. The relationship doesn't magically transform at a certain age, whether that be 18, 50, 35. It's carried through the entire lifetime of that person. And this is not something that, you know, appellant is drawing out of nowhere. This idea is supported in the precedent of this court. We have Doe versus Houck, where the court found that there were, you know, material issues of fact, even on a summary judgment motion, as to whether the victim, who was of the age of consent at the time, consented. Even though there were no allegations there of contemporaneous words or conduct of the victim at the time that would have shown his lack of consent, the court said, well, let's let this go to trial and let him testify and see whether, in fact, he did consent. And that was at summary judgment. Here, we're still at the pleading stage. My client should be permitted to develop the evidence. And then, you know, respondents will have a chance at summary judgment to say the evidence doesn't bear out these allegations.
Just like I get the practicality of it. You're not saying that our court needs to answer that your client, in fact, did not have consent or did not give consent. Now, that could be for another day.
That's right.
All you're saying, you've alleged enough, and then theoretically, I suppose that maybe it plays out this way in practice, but 3211C for immediate trial on this issue, because this is a statute of limitations issue, right? So this comes under 3211A, whatever it is, 5. And 3211 or 3212C allows an immediate trial, including with the jury, of an issue under 3211A. So theoretically, this could go to trial in front of a jury just on the issue of whether or not your client gave consent. And then if the answer is yes, he did, or he didn't show enough that he didn't, the case would be over under statute of limitations, or otherwise it could proceed. Do I have the procedure, like what's coming next, generally correct?
I think that's definitely a possible procedural route that this could take. While you're speaking about procedure, one of the respondents did, at the end of their brief, ask the court to, even if the court agreed with appellant on these issues of statute of limitations, to dismiss the amended complaint based on the other arguments that they raised in their motion to dismiss. Appellant submits this is not the appropriate procedure because he didn't have a chance to appeal the trial court's order or see the trial court's reasoning or decisions on any of those alternative arguments. So the proper procedure in appellant's view would be, if the court agrees with appellant on the statute of limitations issue, to remand back to the trial court for consideration of the remaining issues in the motions to dismiss, which would generate an order that the appellant would then have the right to appeal. I also want to build off of what I think we've been talking about, which is kind of talking about these very unusual and unfamiliar dynamics of why a 53-year-old man wouldn't be able to tell this, you know, similarly middle-aged man that he didn't consent to sexual conduct. And I think the answer to that is found in looking at the spirit and the purpose of the Adult Survivors Act. This is a statute that was passed because there was a recognition of how long it takes for child sexual abuse survivors or survivors of adult sexual assault to talk about what happened to them and to come forward and come to the court and seek redress for what happened to them.
I'm not trying to minimize that argument, but we don't need to address anything like that in our decision here at this stage, correct?
Well, I think the trial court, underpinning the trial court's decision, was a real misunderstanding of those dynamics. So I do think it is relevant to the court's consideration of appellant's argument, because I think the trial court was basically saying, you know, all of these years passed between the child sexual abuse and the adult sexual conduct. And the passage of those years somehow made the adult sexual conduct voluntary and consensual. And I think, I mean, if you look at the legislative history of the Adult Survivors Act, it was really passed to address the opposite conclusion, which is that it's just these dynamics are very complicated, and what a sexual assault survivor goes through and in being able to face his perpetrator and being able to.
This is in the complaint, you would say that's not something we need to decide now. You've alleged enough in the complaint, so it can go forward despite the.
That's right, Your Honor.
Got it.
If the court doesn't have any other questions, I'll rest on my brief.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court. Appellant conceded a moment ago that a plaintiff alleging a claim under the Adult Survivors Act is required to plead allegations of lack of consent. That's indeed consistent with what this court held in Druger versus Syracuse and in Shapiro versus Syracuse. Allegations supporting lack of consent. What do we have here? Where do those allegations come from? Those come directly from Penal Code Section 130.05. Lack of consent can result from forcible consumption, incapacity to consent, or Section 2C, where the offense charged is sexual abuse or forcible touching, any circumstances in addition to forcible compulsion or incapacity consent in which the victim does not expressly or impliedly acquiesce to the actor's conduct. What are the cases that have looked at that last section, interpreting the language expressly or impliedly acquiescing to the actor's conduct? Those are cases like we cited: Parbu, Kal, Yarvu Sarkuk, Hatton. They look at the individual instance where the sexual conduct occurred and ascertain whether in that moment the victim, by words, conduct, something indicated they lacked consent.
Where does Druger fit into that analysis?
Druger's was not decided on Section 2C. Druger has stood for the proposition that you have to allege lack of consent. In the opinion of Druger, the court noted that the victim, the plaintiff in that case, had alleged specific allegations under Section 2A for forcible compulsion, because I believe it was a rape-related allegation. So they were able to satisfy the pleading standard.
They didn't allege any particulars. It was just parroting the statute and said that it was done by force without consent. What the argument from the defendant is we need specifics here of what exactly what's the underlying conduct. And we said in that case, that's a matter for discovery, bill of particulars.
But they at least alleged it. And that's the predicate of what they need to get to the point of discovery is you have to allege the lack of consent. And those are the grounds you can do it: forcible compulsion, incapacity consent, and when the victim does not expressly or impliedly acquiesce to the actor's conduct. There's no allegations as to forcible compulsion. There are no allegations that fit within the Section 2B incapacity consent. Incapacity these are defined terms: less than 17 years old, mentally disabled, mentally incapacitated, physically helpless, all defined under Section 130 of the Act. There are a number of other protected classes of relationships that are subject to Section 3. The dynamic that counsel had referenced about some type of lifetime relationship with someone who they knew as a child, as an adult, that is not one of the enumerated protected classes found anywhere in the statute. There are no grounds under which plaintiff has pled lack of consent as required by this court. So what we were left with is three conclusory allegations in the complaint. The allegations are: I lack capacity to consent, and the sexual conduct was not voluntary. There is nothing in the body of the 136 paragraph complaint where plaintiff went through each instance of each time there was sexual conduct supposedly allegedly occurring under Penal Code Section 130 and identifying what they supposedly did or said or expressing in some way that they did not consent to the sexual conduct. Now, the Doe versus Hawk case that is important That's what counsel just cited. That was another Fourth Department case, and it stated for the statute of limitations purposes, only where the plaintiff lacked consent within the meaning of penal law section 130.05. That's the conduct that is predicated for stating a claim, at least under the CVA. And the court said otherwise that would not constitute a sexual offense under section 130. And so the analogy that the court referenced just now, this employer-employee relationship where there could be financial or other incentives, that may be some type of claim, but it is not the type of claim that would have been revived under the predicate requirements to state to have a cause of action revived under section 130.
Did you look at the Judge Shiano's decision in the Gates Chilai case?
I did, Your Honor.
And that the defendants there were arguing that psychological grooming over time, that is equal lack of consent. That was the argument there. That seems to be the argument here. That this plaintiff he was groomed and psychologically programmed here such that he could not consent. You don't buy that as a viable theory?
Well, that's not why the case was permitted to proceed in the SR versus Gates case. The inquiry the court looked at was whether or not this age limitation between the CVA, which says that a child under the age of 18 could have her claim revived, whereas the legal age of consent was age 17. So the court's job there was to reconcile whether or not a instance where conduct occurred where the victim was age 17, whether or not that would fall within the parameters of the CVA. But the actual argument the defendants raised in that case was not only they argued that the age of 17 was not incorporated into the CVA, but they said that there were facts alleged that, in fact, that the plaintiff did consent. So we are still looking at something, so by words, conduct, anything and all, if it's under section 2C or forcible compulsion or incapacity to consent. There has to be something there. It is not the generalized perception of how I feel about someone in my life that gives me the authority to state any of these claims, which is what the appellant is arguing here.
Anything further, counsel?
Last thing I'll mention before the court, Judge, in the briefs, the appellant would said something along the lines of that they need this claim to move forward because otherwise they would not be able to seek justice against Mr. Fine. And that's not true because of the many alleged instances of sexual conduct that occurred prior to the age of 18, the appellant has a separate CVA claim against Mr. Fine pending in the courts now.
Same defendant, Syracuse University defendant in the CVA?
Syracuse is not. I believe it is Mr. Fine. I believe it's the county. I believe there's one other defendant. I don't have all of those in front of me, but it has recourse.
They're deep. I mean, it's a case where they could collect if they win.
I can't speak to the viability of collecting against a government agency, but
if they can't collect in the CVA, then this would be the only avenue to pursue.
There's nothing in the record to suggest or otherwise to say that they have no ability to collect from the defendants in the CVA claim.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Mary DiAgostino on behalf of Syracuse University. I don't have much to add beyond what counsel just addressed. I think anything that I could add would be repetitive, but I will say the CVA case that's pending in Onondaga County right now, it is against Mr. Fine. It's also against the city of Syracuse, and it's also against the county of Onondaga. But unless the court has any questions, I'll rest on my brief.
No questions, counsel. Thank you. Case 153, City of Rome versus GHD Consulting Services, Inc. Very good. Let's start with Mr. Capriati. Can you hear us?
I can. Can you hear me?
We can hear you loud and clear.
Right.
Mr. Sear, can you hear us?
Yes.
Very good, thank you. And Mr. Flynn, can you hear us?
Yes, I can, Your Honor. Good afternoon.
Very good, thank you. Okay, proceed, counsel.
Thank you, Your Honor. May it please the court, David Capriati on behalf of the City of Rome, the plaintiff appellant. There's a couple of different things that I would like to make sure that the court is aware of in relation to this case. The City of Rome found itself in a situation that it needed to build a UV facility to sanitize its water. To do that, it hired the defendants, essentially. GHD was the owner agent. They designed and engineered the facility. Falter was the general contractor, and Beacon and Patrick were direct contractors, all of which had owed their duties, had responsibility for the means and methods that they were going to do their work, and most importantly, that they were adhering to the contract and regulations of the state. It's important to understand for this case that there is a UV facility that has all kinds of equipment in it, high-tech equipment, frankly. And then on the side of that facility is this chlorination room that is the subject of this case. Chlorination room is a relatively small room that is attached. The chlorination room is used in a situation where there's an emergency, the UV facility is not going to work, and that has chlorination canisters in it.
Right. Counsel, we are familiar with the facts, and we understand what happened here is that one of the tanks, 150-pound chlorine gas tanks, has frost on it. The city's chief operator, Mr. DiPaolo, goes in there with others and tries to take that offline. The gas escapes and then it goes into the UV facility because it wasn't sealed.
Correct.
So the issue is, assuming negligence by these defendants, was there some intervening superseding cause here? The trial court found that Mr. DiPaolo acted recklessly and that was a sufficient intervening cause. You disagree with that version, stressing that we must assume the truth of all of DiPaolo's testimony. Everything he says he did, including with the wrench and closing the valve and double checking that, we have to assume that actually happened. We have to assume that he did not hear, that the other people in the room with him did not advise him not to do that. All these facts we need to assume in his favor and then look at it was he merely negligent? Was it reckless? And if so, whatever his conduct was, is it so egregious as to sever causation?
Judge Lindley, you just nailed it. If I could just add a couple of things to that, though. Unfortunately, the papers it sort of turns the standard on its head. They use various different other pieces of testimony, which are refuted by Mr. DiPaolo's testimony. And unfortunately, the lower court followed suit by finding inferences in favor of other people's testimony. But the simple truth is, the standard is that all inferences have to be viewed in the light most favorable to the non-movement, and exactly the opposite happened here. In fact, when there was hyperbole about Mr. DiPaolo acting maniacally and temerariously, and just like some crazed man went into this room. John Hill, who they kind of propped up as an expert, even testified that the ball in the rotometer can absolutely get stuck, and in his experience, it's happened before, and that what Mr. DiPaolo did was not at all unreasonable. But even if it was, changing a tank and the gas leak was completely foreseeable. And under those circumstances, under any circumstance, a fact finder would need to make a decision as to whether Mr. DiPaolo acted reasonably, whether he acted recklessly, which even if he did act recklessly, which I respectfully submit, the court really can't get there. The lower court shouldn't have gotten there. That doesn't that is not a superseding cause.
There's a difference between negligence and recklessness. And it does, a decent case could be made that DiPaolo made some mistakes. So he should have waited for a hill. There was no urgency in disconnecting that tank. Could have waited a few minutes. He was gambling on his understanding that he did close the valve so that rotometer, the ball, that was not accurate. Arguably some negligence there. And in retrospect, I'm sure he wouldn't have done it the way he does. That he wouldn't do it now the way he did it then. But to get to superseding cause, do we need more than just mere mistakes or negligence?
Absolutely, Your Honor. The Court of Appeals has made it very clear that liability turns on whether the intervening act is a normal and foreseeable circumstance or consequence of the situation that was created by the defendants. The situation that was created by the defendants is moving chlorine canisters into a room that is not finished, it's not sealed, and it doesn't comply with the contract or the state regulations. And then go further than that, they create a situation where they're going to utilize that chlorine system over a 4-day period. And inexplicably, even though there were citations in the record that seemed to suggest that the city was in complete control of this project, that is the furthest thing from the truth. But more to the point, they weren't in control of this because when that bad decision was made that the defendants created, they all literally went home for the weekend and said, okay, City of Rome, you monitor this room. And so Tony DiPaolo was, and the city was put into a situation that was created by them. And then under the case law that we've cited, it is very, very clear that the intervening act cannot be a superseding cause where the risk of the act itself is what renders the defendants negligent.
It seems like there are a lot of bad decisions here, but one was changing the lines before the chlorine room was sealed. And there was some talk about maybe Garrison wasn't available and we had to get them while we can. It seems to be a dispute as to whose idea it was to go with this alternate A plan, the timing sequence, who was in charge of sequence. There seems to be a lot of issues effect on that, which would go to the defendant's negligence, but that's not why we're here today. We're assuming that these defendants were negligent in one form or another. Is DiPaolo's actions so out of the norm, so reckless, so unforeseen that it doesn't matter if the defendants were negligent?
Correct, Judge Lindley. You're spot on. It is a one link in the chain of proximate causation here, and it is absolutely does not rise to the level of some intervening act or superseding cause, because what it is Tony DiPaolo having to go in and change a chlorination tank. The risk itself, what is the risk of going forward using this room when it's not sealed? A gas leak. That's exactly why it needs to be sealed. And changing a tank over a 4-day course is 100% foreseeable. So there is absolutely nothing about what happened that is unforeseeable or gets to the level of superseding.
There's a downside to not switching out that tank, which is that the tank that was working fine might run out over the weekend, and then this water is not going to be properly decontaminated. They were using the chlorine to clean the water until the UV was ready. So it's not like there was a legitimate reason for him to be concerned. Again, he might have done things differently, but it was out of concern for the water supply, I think, is what he was acting on there.
Yes.
Counsel, anything further?
I do not. Thank you.
Thank you. Very good. Mr. Sutter, I think you're up.
Yes, Your Honor. Thank you. I'm Brian Suter on behalf of GHD. We were granted summary judgment below and believe that order should be affirmed.
In this context, somewhat similar to what the court below seemed to have found, that we have cases this effect, Mr. Suter. I think that we have to assume that your client was negligent.
Absolutely.
Okay.
I get it. The issue, though, is what's the time period that matters? The time period that matters is when Mr. DiPaolo says or notices That ball isn't moving. And Mr. Olney and Mr. Dombrowski tell him that ball's not moving.
Well, isn't there an issue of fact on whether they said that?
There isn't.
There's not?
There isn't. Mr. DiPaolo was asked at 2103 of the record, before you took any steps to disconnect the tank that had been frosted, did anyone suggest to you that you didn't have to do that? He said, no. He went on to say why it wouldn't have mattered if anybody said that. Remarkably enough, there were 3 attorneys, 2 very competent, thorough attorneys, and myself, who questioned Mr. DiPaolo. He was never asked, did Mr. Dombrowski tell you, don't do this after the ball didn't move?
Let's assume Olney and Dombrowski said, we don't think that's a good idea. We know that DiPaolo was the supervisor. He's been doing this. He's been changing the tanks himself with another worker for a long time. I think everyone would agree, and I think everyone agreed below. If DiPaolo used his wrench and he closed that valve, there's no way gas should be getting out, right? And if he did that, and he's sure he did that in his mind, and we have to accept that he did shut the valve, then there were that rotometer, the ball in there was not accurate.
And that's why you don't just go forward. Those 2 things don't go together. He didn't take a second to investigate.
As I said, I'm not sure anyone's saying DiPaolo handled this perfectly. Could well have been negligent. But what's the standard here for intervening cause? It's not terribly unforeseeable that if there's frost on one of these chlorine gas tanks, and there's a concern as to the sanctity of the water, somebody's going to try to do something.
And if it was me, for sure, it's foreseeable that I'll screw it up. But it is not foreseeable that the man entrusted to run the plant, to instruct the employees of the city of Rome, will push right through, regardless of 2 of his underlings telling him, this doesn't look right. That's unforeseeable. And that's where it goes from negligence to reckless. It wasn't like he just stumbled in there and didn't know what he was doing. He's supposed to know what he's doing.
He closed the valve. We have to assume he closed the valve.
He thought he did. And we know that he didn't. And he admitted he didn't because the chlorine came spewing out. He definitely thought he did. We can accept that. He thought he did everything right. We can accept that. But he didn't. Or something happened. For example, maybe there was something wrong with the valve. Again, you don't just keep pushing through. You're faced with, I closed it. The ball's still up. I'm going to keep right on it going. That's reckless. And to your point about, chlorination of the water, we know the tank that was running, that was hooked up, could have gone for a couple of days. So there was no hurry. There was no reason to do it. That's why it's reckless. In the face of his co-employees telling him, don't do it. And he did it anyway.
Anything further?
I don't think so, Your Honor. Thank you.
Counsel. Mr. Flynn, are you up next?
Yes, I am, Your Honor. Good afternoon. Mr. Sutter summed it up very nicely. Mr. DiPaolo's actions were totally unanticipated. They were reckless in nature. They were unwarranted. He was told repeatedly by his co-employees that the ball had not dropped, that the chlorine tank was actively discharging chlorine. And to compound matters even further, Mr. DiPaolo was well aware that the tie-in process undertaken through Garrison had been approved by the city of Rome and by the mayor of the city of Rome as well. And the substitute chlorine tank, as Mr. Sutter had mentioned, would have run for at least a couple of days. And confronted with those facts, Mr. DiPaolo didn't do anything to bring in the city of Rome engineers, any of the contractors, or undertake any type of reasonable measures. He unilaterally disconnected an actively flowing chlorine tank when he was repeatedly told by every city employee that he spoke to, don't do anything, hold on. Had he done nothing, none of us would even be here. It was absolutely reckless, his conduct, and it's the sole cause of this.
Had the room been sealed, we wouldn't be here.
Well, there are
that gas escaped. The 3 people in there, fortunately, they're fine. Nobody's hurt. The damage was caused to the UV room because the chlorine room wasn't sealed. So you can look at it that way as well. But for the failure to seal and decision to go ahead in the sequencing of this before the room was ready, we wouldn't be here either.
However, there was a change order number 3 that was approved by the city council and signed off by the mayor, Mayor Izzo. So this timing of events was approved by the plaintiff. They were well aware of this. This was deliberated upon and approved by the mayor and the city government.
Okay, thank you, counsel. Anything further?
No, thank you. Thank you.
Mr. Desari?
Thank you, Your Honor. May it please the court, Nick DeCesare on behalf of defendants Beacon Contracting and Patrick Keating. Obviously, we've been through this. I won't belabor the points. I'd just like to briefly address 2 things. One, the standard is extraordinary under the circumstances, right? That's what gets you over the hump to get to the intervening cause. And that's looking at all the circumstances. And that's, you look at the Egan case, the Bull tax case, which are cited and discussed in the briefs, Court of Appeals cases, the one Bull tax involving the individual who dove into the shallow pool, the Egan case, the construction worker who jumped out of the elevator. And just to counter Mr. Capriotti's point of, the gas leak being inevitable, that's the damage, that's the foreseeable. Well, it's foreseeable that someone diving into a shallow pool could be injured. It's foreseeable that someone jumping out of an elevator could be injured. The fact is that this Mr. DiPaolo, the man with 30 years experience, and just looking at his own testimony, he knew that the ball in the rotometer didn't go down to 0. He speculated as to why that might be. Hey, the guy jumping out of the elevator speculated he would be okay making that jump. The person diving into the pool speculated they would be okay diving into the pool. That doesn't make their conduct, that doesn't break the chain of making their conduct extraordinary under the circumstances. Looking at Mr. DiPaolo himself, again, he admits the ball did not drop when he closed the valve. It's possible there was gas, therefore still flowing. He was trained for 20 plus years on the threat of chlorine gas, not only to himself, but to equipment and the environment. He didn't contact anyone. Well, he did, and the guy he contacted didn't show up. And he did this within 15 minutes of showing up to the scene. He didn't take any time to evaluate what might be going on. He didn't take time for the heat to increase in that room, even though there's testimony that the heat was turned back on and the room was warming up. They had brought in a portable heater. He testified that he knew the room wasn't ready for this to be occurring in it. He knew it wasn't sealed. He stated repeatedly that there were missing safety devices. And what did he do, knowing all these things? This man with 30 years experience, head of this plant, he didn't stop for 20 minutes to wait for somebody else that he had called for their expertise to come in. He didn't listen to his co-employees. He didn't give any credence to the fact that the rotometer didn't go to 0. He didn't give any credence to the fact that he had another tank that was operating perfectly fine, that was going to fluoridate or chlorinate this water for 2 days. He took off the regulator knowing that the rotometer didn't go to 0. And that, Your Honors, under Egan, under Bull tax, under other cases that are cited, that is extraordinary under the circumstances. That is an intervening cause that cuts off liability for any defendants after that. Thank you.
We'll take a look at that, counsel. Thank you.